Your legal career started a long time ago, in 1984 already, as a legal assistant in the Kangwane Government Department of Justice. What did you do there? You must have been fresh out of school at the time.
Yes, I started work 3 days after coming back from the university. They had given me money, a bursary loan. So when they heard I was finished, even before the results came out, they said, come, start working.
What kind of work did you do?
It was to assist the Secretary for Justice with legal work. I dealt mostly with correspondence that dealt with claims that were being lodged against the government of Kangwane. I wasn't the lawyer, but just dealing with the correspondence and interacting with the state attorney's office.
Yeah. You would later move on to the Legal Resources Center in 1987 as a fellow.
That is correct, CJ, yes.
Gottwarmer became a candidate attorney at Bowman, Gilfillan, Heyman, Godfrey, Incorporated in 1988.
Yes, yes.
Worked your way up there until you became associate partner in 1993.
That's correct, CJ. I was generating associate partner fees when I was a candidate attorney. And one of the partners said to me, what were they going to do with me? I said, well, treat me fairly.
Yeah. It was not usual, you will admit, for a black person to become partner in the Big Five in those days, was it?
No, it was a rarity. I never made full partner. I was
As well, even associate partner.
associate partner, yes, yes. It was a rarity, it's true, CJ.
Yeah. But then you took a leap of faith and started your own practice on your own account in 1994.
Yes, I started, and then my long-term friend, although he was from Wits, Mr. Leivre Modisa, joined me. And the firm became known as Mlambo and Modisa Attorneys. Yeah.
You were not given a long time to settle into your practice because you were snapped up by the judiciary in 1997.
That is true. The chase started in 1996, and I resisted it. Felt I was not experienced enough. But Chief Justice Mohammed was very resolute in saying there's a new constitutional dispensation that requires people to come and support the new constitutional project. So in 1997, they eventually ensnared me into the judiciary.
Yeah, that's a call that was made to a number of us, which was impossible to resist. You were a judge in the labor court for, was it 3 years? 1997 to 1999. And then moved to the High Court in 2000.
I started acting in the High Court in 1999. I was actually surprised when Judge President Ilof called me directly to invite me. So I was acting, and then 2000, I think that's when I was appointed permanently, if I'm not mistaken. Yeah.
Your questionnaire does not make that clear. So you were at the High Court until 2005?
That's correct, but I started acting in the SCA in 2003, I think, and never came back to the High Court.
When were you appointed to the SCA?
In 2005, I think.
But it took a bit of time for you to report in Bloemfontein for some reason. When did you report for duty?
Report to, sorry, CJ?
When did you, I'm saying that I remember that you were appointed permanently in 2005.
Yes.
But you did not immediately report for duty there. It took you a bit of time while you were winding up your affairs in the labor court or in the High Court?
Oh, yes, I remember. Thanks for reminding me, CJ. Yes. I was allowed to spent, I think, probably 9 or 10 months in the labor court to finalize, labor appeal court, that is, to finalize work that was there before I took up the appointment in the Supreme Court of Appeal.
Then you did report for duty and stayed in that court until 2010.
I did, CJ. You remember that's where I first met you.
Yes. And you were there until 2010 when you were called back to the labor courts.
That is correct. In 2010, the acting JP at the time, JP Wegley, paid me a visit and asked me to stand. I thought it was uncalled for because he was the one who was supposed to take over, but he was the one inviting me. I resisted, but I eventually, when the whiff of leadership hit me, I decided, well, that was the way to go, and I accepted.
Yeah. And you would not stay there for a long time. Another call came for you to make your way back to the High Court was it in 2012?
That is correct, CJ. I got a number of nudgings from a number of angles to avail myself. I had not intended to because I was already ahead of court, but I eventually acceded, and here I am, JP Gauteng.
Yeah. And here you are today. You have been in leadership for a long time in this institution, JP Mlambo.
That is correct, CJ. I started in 2010 as head of court.
And I know, and if some of us know, just how much you have done in that time. Would you just highlight for us some of the key things you have done, you have initiated and implemented to improve the lot of the judiciary and our people?
Thank you, CJ. And I think I was remiss. I should have greeted all the commissioners properly, the president of the SCA, the minister, JP Hendricks, all the commissioners. Please forgive me for not greeting you properly. CJ, when I took over as JP of the Labour Court, there was a raging debate in that court whether the LAC should become a chamber of the SCA. I'm sure you remember that debate at the time. And there were two schools of thought in the LAC about whether they should be a chamber or whether they should stay as an appellate court in their own right, and whether their appeals should still go to the SCA or should go to the Constitutional Court. But I encouraged that discussion to continue, and I think we ended up agreeing that the LAC was better placed standing as an appellate court in its own right in labor matters. But the focus of my attention when I took over in the labor court was in a dysfunctional state, that court, to put it mildly, in the sense that files were being lost routinely. I think the issue of the allocation of trial dates, review application dates, was still based very manually. Remember the 5 registrars who each held a diary. And the routine loss of files, as well as the duplication of case numbers, said to me, someone needed to reform the whole case flow system of the court. And I remember asking for extra hands, and I was granted an opportunity to employ 3 more legal interns to go through all the court files that had been lodged, because some of them were files that had been lodged but that had not been processed, but they remain active or live. And I remember at the end of it, we had identified a number of files. Those that had not been actioned in more than 3 years, we archived immediately. And those that were this side of 3 years, we wrote letters to the parties to say, They needed to tell us what they wanted to do. If they didn't want to do anything, we would archive those files. And that freed a lot of space for new cases to be lodged in. I think in 6 months, I want to believe I had turned around the functioning of the Labour Court. There was no problem with the Labour Appeal Court, but just as a conduit to the Labour Appeal Court from the Labour Court, a number of cases that should have gone there earlier were not going there earlier. So the cleanup that I did enabled matters to start going to the Labour Court appropriately. I think the other thing that I did is to reignite the relationship between the leadership of that court and NEDLEC. NEDLEC plays an important role in labor law in South Africa, especially the functioning of that court. This commission knows there's NEDLEC presence, even though not at voting stage, in this court when labor court candidates are interviewed. So I left in the happy space that a number of key amendments to the Labor Relations Act would now be in good hands at NEDLEC through the leadership of the Labour Court. But then I had to leave and go to the High Court. When I was at the High Court, when I stood for the High Court, I identified a number of fault lines. One of them was judges in the agent court, in the High Court, in Gauteng, regarded that court as hell. Only one judge did the agent court in a week, that is day and night and weekends. And I said, that's impossible for one person to do it. And I introduced a 2-judge system. And the rest is history as how judges are able to manage the load of that role. But I also identified that there was a problem with part-head trial dates. The norm was a part-head civil trial only came back after 3 years. And that was inimical to proper access to justice. And I introduced a system where I enabled judges that whenever they are sitting in a civil trial that they realize was going to become part-head, before that matter ended in that first sitting, they should source dates when they could be available in the following term. And I would factor that in the roster that I would issue for the next term to make sure that there's continuity, right, with the trials. That was the other thing. And the other thing was to reform the opposed motion litigation in Johannesburg. In Pretoria, the opposed motion was reformed in such a way that judges received their files 2 weeks before the matters were to be heard. And that enabled them time to read and prepare so that they didn't have to rely on counsel to take them through their papers. And Johannesburg had been resistant to that way of doing things. I know it was a mammoth battle to convince the Joburg Bar in particular. Judges understood the benefits of the new system, but I succeeded in making sure that the litigation system in the opposed motions is the same in Johannesburg and in Pretoria. What I also eliminated, Chief Justice and Commissioners, was the red card system. The red card system applied to matters in the civil trial role, that if you'd had no allocation by Friday, you then had to go back and start afresh in getting a new date. And I felt that was inimical to access to justice. And I ended it and cemented the issue of appropriate roll call by the DJPs, as well as ensuring that the civil trial role judges are increased in such a way that they are able to deal with each week's load that comes. And that got rid of the red card system that applied. It applied a lot more in Johannesburg than in Pretoria, right? Those are the initial things that I did, CJ. But there are a number of other things. I was appointed by Chief Justice Mlambo to head the Judiciary IT Committee simply because I was the only head of court who came to meetings with a laptop. And I remember one meeting, JP Mwepe happened to sit in my seat in front of the laptop, and the JP Mlambo remarked that there was something wrong there. The laptop and JP Mwepe. I won't discuss what he said was wrong, but he appointed me to head that committee. I continue to head it, and in that position, CJ, we've been able, as that committee, to introduce case lines to the South African judiciary. It's a revolutionary way of electronic case management and case filing. It came in very handy during COVID. We've gone further. We've now cemented the implementation of Court Online, which is the proper e-filing and litigation system, where files will then be bundled onto case lines, which is an evidence management platform. So those are some of the things I've done, CJ. I've introduced committees. I mean, at my instance, when I saw the rise in fraudulent court orders, I persuaded Chief Justice Mukwege to establish the Court Integrity Committee to track and monitor the incidents of fraudulent court orders that were being used, and to establish a relationship with the DPCI to regard those offenses, court-related offenses of that nature, as priority crimes, and to fast-track their prosecution. Unfortunately, we've laid many criminal charges against the people who use fraudulent court orders, but DPCI still has to come to the party because those matters are routinely withdrawn. So there are a number of other things, CJ, unless you want me to mention them, but can I stop there? I can deal with the others that commissioners may want to raise.
Indeed, there are many others. You play quite a number of roles in the heads of court cluster. And you've only mentioned just one of the things you do there, but I think that's enough. Court modernization and digitization and the work you do as JT, I think is a big enough undertaking. So point is taken, JP Mlambo. While you were doing all these things within the judiciary, you were doing other significant things outside the judiciary, quite a number of other things, and I highlight only two. Your role in the global executive, well, that's a role you've since assumed. Your role in the IARMJ, of which you are now executive council member, heading as chairperson its Africa chapter. Yes. What is the IARMJ? It's quite a mouthful.
It is the International Association of Refugee and Migration Judges. It is, incidentally, it was launched here in South Africa in I think it was 1989. No, not 1989, I think 1999, if I'm not mistaken. It is an association of judges internationally who have an interest in the development of refugee and immigration law. Because of the migration patterns that sees South Africa being a favorite destination in this continent, and not only drawing continental Africans, but also people from other continents. When I became JP Mwepe encouraged me to join that association. And our interest as an association is that we take no sides, because we are composed of 4 chapters globally. It's the African chapter, of which I'm the president. And then you have the European chapter, which has seen a lot of developments around the international instruments. And then the Americas chapter, as well as the Asia Pacific chapter. All of these chapters bring different dynamics onto the table about the development of refugee law. So the main focus of the association is to run professional development programs, especially continentally and globally when we meet every 2 years, to keep each other updated of groundbreaking judgments in whatever continent they are, or even in this continent. And I can tell you, CJ, a lot of the jurisprudence that's generated from South Africa plays a central role in the jurisprudence discussions of these associations when we meet during the world conferences. So ours is to develop ourselves as judges to understand what we are dealing with. We have the UNHCR as a very big partner in this regard, which has the sources of case law and other international instruments that apply to this field, which is the go-to place when you are looking for any document. There are experts around the world, even South Africa has experts, that also take part in the professional development engagements that we have. I've been successful in organizing a very big conference of the Africa chapter in Arusha in 2022. And then the last one was last year in Sharm el-Sheikh, Egypt, where we bring judges from the whole of Africa coming to look at what's happening, to share their country dynamic experiences, as well as to learn about what's happening and how to deal with refugee and immigration law. And the interesting part, CJ, is, when you meet judges from the civil law jurisdictions, you get to understand how they do work, how the executive remains a very dominant player in the affairs of the judiciary in those jurisdictions. But we meet, we mingle, we learn. So that's the major focus area of the Refugee Law Association, Chief Justice.
You did not mention the work you did at the Legal Aid Board, where you were involved for, was it 17 years, between 2002 and 2019?
Yeah, CJ, yes, I was, that's another role where I was ensnared by Justice Nafsa and the late Justice Chaskalson, Chief Justice Chaskalson. They invited me as if it was going to be a morning meeting, but then I found myself being a board member. Hardly had I settled down, I found myself as chairperson, but I didn't look back. That was an organization that needed serious attention. And I think that's the entity that gave me a different perspective as a judge to see how things actually happen operationally when you are in charge of an organization that has a budget that side of 2 billion, and how you see how that budget, you track its monitoring and how you account to the Attorney General for how you've used the money. I've been to the Portfolio Committee and to SCOPA as chairperson of Legal Aid a number of times to come and deal with issues that were being raised around Legal Aid. And at Legal Aid South Africa, 2 very important developments happened under my watch. The first one was to reduce and minimize the judicial system, because we viewed that as money going down the drain. We could not see the results of the cases that were being handled on judicare. And we introduced the salaried lawyer model to say, if you tighten performance management of these lawyers that were getting a salary, and you control the caseloads they have and the courts that they attend to, you could get a lot of work done. That is, you can get little money, go very far, as opposed to the judicial system, which had become very expensive. So that was the one thing. But the other thing, hand in hand with the salaried lawyer model, was we introduced the Justice Center model. The Justice Center model was to establish a center in particular areas where you have paralegals, lawyers, and what we call high court units, although the high court units came later, where you have advocates or senior attorneys who service only high courts, whereas the lawyers service magistrates' courts. So the Justice Center model, CJ, has become the preferred model of providing legal services to the indigent internationally. During my term as chair of Legal Aid, we hosted not less than 10 international delegations coming to Legal Aid, coming to learn about what we were doing and how we were doing it and how we could assist. I also traveled extensively. I remember going to India to train legal aid personnel from, I forget this country now, but we couldn't go there because of the political influx. I'll remember the country now, where we were training them. But that was not the only country where we went. We assisted actively. Botswana is one example, where we assisted them come up with their own Legal Aid Act, right? Even though the Legal Aid Act of Botswana emphasizes more civil legal aid than criminal legal aid, they still use the Prodeo system, but it's a very efficiently run Prodeo system that they run in Botswana. So I ensured that the Justice Center model gets mileage throughout. And as long as we have the will of government, fortunately in South Africa, the Department of Justice is a very willing department under which the Legal Aid South Africa resorts to provide the funding and to support the funding of that entity. I remember when budget cuts were first introduced, the impact was going to be terrible because that would mean less lawyers. And when I went to meet Minister Hadebe at the time, who I reported to say, Minister, we are going to close these. We're not longer going to service these courts because we don't have the personnel, right? And then he said, no, you must tell that to the Minister of Finance. And when Minister Manuel heard the story, they didn't introduce budget cuts for Legal Aid South Africa for that reason. So, but I think the other important thing is to put Legal Aid South Africa on the international stage, Chief Justice. I attended a number of sessions in Vienna, right, of the UNODC. And two of those were seriously involved, where I was appointed to chair two expert groups. I remember the first one, that 43 experts from 43 countries to settle the UN principles and guidelines on access to criminal justice internationally. And it was a 5-day project and very successful. The other one was settling what is called the Mandela rules, which has to do with the treatment of prisoners. That was a 5-day process in Cape Town, but it had taken the previous 4 years to come to that stage because they had not reached consensus. Even there were about 46 countries or 44 countries that were represented. I was also appointed to chair that one and negotiate until they actually came up with the document that we have today called the Mandela Rules. So, but the upshot of it is Legal Aid South Africa became a big player in criminal access to justice internationally, because that's where it is located in Vienna in terms of the UN arrangements. Let me stop there, CJ. There's a lot to say.
And there are, of course, a few other bodies, similar bodies in which you are involved. But you've given us quite enough in that regard. Back to your work as a judge, as head of court, you sit in PEC and NEC. Would you just tell us a bit about these bodies, what they do, and your role there?
Thank you, Chief Justice. The PEC is a provincial structure that brings on stakeholders in the justice system of that province. So you had the provincial leadership coming, infrastructure, the police, prosecution, legal aid, you name them, they're all there. Even the magistracy, they come there. It is a structure where we look at the bottlenecks and the problems that are bedeviling the proper access to justice in particular courts or in the province in general. And it is a very useful structure to have Chief Justice, because that way we are able to make the provincial leadership of structures that may be causing the bottlenecks to come and account why they're not doing what they're supposed to do. The biggest challenge that we've had over the years was the infrastructure-related challenges that come to the PEC, where you'd have no attendance from officials from the Department of Public Works. That has been addressed in a sense, because JPs are now reporting that DPW officials are now attending that, and they are now accounting. Because it's one thing to attend a meeting, it's another to ensure that projects have traction. And that's the biggest issue. And through your support, Chief Justice, when you were appointed, you took over from Chief Justice Zondo, who had initiated a ministerial committee that actually addresses infrastructure-related challenges in the judiciary nationally. So the PEC plays that role, case flow in particular, as I said, and then other issues. And then, if issues can't be resolved at PEC level, they get escalated to the NEEC, which you chair, Chief Justice. So that's where the national leadership of these key entities must come and account why these projects are not moving. Despite our best efforts, Chief Justice, some of these projects still don't move. I mean, the Pretoria Magistrates Court was banned more than 10 years ago. It is still being reconstructed. It took, I think that project was dormant for about 6 or 7 years when nothing was happening. And it was through the efforts of Chief Justice Mogoeng to actually hold a meeting at Civilton, where he went on national TV to lambast what the DPW was not doing to delay projects like that. I mean, the other court that bent down was the Polokwane one. It also took a long time, but that has now been finalized. So those are the type of things, because infrastructure-related challenges, Chief Justice, have an impact on how the judiciary works. There are horror stories that you hear of magistrates that won't sit when they don't have water. And you find that the simple reason is that there's been no payment, right? Or you find magistrates that don't sit when it's the rainy season because the roofs leak. So these are the types of issues that we deal with at PEC and at NEEC level.
Yeah. You were part of the high-level delegation that recently and very successfully negotiated the judiciary's full independence with the executive, not so?
That is correct, CJ.
And made a powerful presentation on behalf of the institution in that gathering.
Thank you, CJ. I thank you, CJ, because you have an inclusive and team leadership style, and you included me in that team and you allocated me that role.
I won't say no to the compliment. Thank you, JP. I want to ask you about your core function as a judge, which is to sit in court and listen to cases and, importantly, produce judgments. I think that the body of judgments you have produced, and you count about 176, I think it speaks for itself. I will leave it to other commissioners if they so wish to deal with that later during the interview. But suffice it to say, you have written judgments on the widest spectrum of legal issues, as I see.
That is correct, CJ. I mean, it's one of the issues you have taken up and ensured that it is addressed. The president of the SCA is sitting next to you. She will testify to this. As heads of courts, we must sit in these matters. But because of the demands of our work as heads of courts, we don't sit as much as we would like to. One reason is the demands of our work as well as the capacitation of our support structures. If I've got to sit in court and rely on researchers, in Pretoria there's 6 researchers. In fact, there's 5 now because we were involved in a fight to fill in the other position. All the other 44 judges of the division rely on those 6 researchers. And if I have to come, I also have to rely on that. So it's a very difficult situation to find oneself in, but we still try. We try our best to do that, yes, to sit in cases.
All right. We are going to give you a bit of time, no longer than 30 minutes, to tell us what your understanding is about the role of a Deputy Chief Justice and how you intend to fulfill that role if you are appointed.
Thank you very much, Chief Justice, and thank you very much for this opportunity to deal with my understanding of the role of the Deputy Chief Justice. And I think I also thank the Commission for interviewing me to assist the Commission in assisting the President appoint the next Deputy Chief Justice. I say up front that it would be an honor for me to serve as the next Deputy Chief Justice. My view is the Deputy Chief Justice is a very important position in supporting the Chief Justice and the work of the Constitutional Court in particular, in carrying out the constitutional objective of a just and socially transformed South Africa. I emphasize that the judiciary, but more the Constitutional Court, has the function allocated to it by the Constitution to be the arbiter of disputes that relate to the exercise of public power. And that is a very mammoth task of the court, the Constitutional Court in particular. And I think the Deputy Chief Justice, being next to the Chief Justice, is key to the success of this constitutional project of socially transforming South Africa. My view is, and this is based on myself, I regard myself as an activist judge. I know a lot of people have quibbled, what do you mean? I can still say I'm an activist judge because I understand my role in terms of the Constitution, which is to use the law to ensure that South African society is adequately transformed based on what has happened in the past apartheid years. And in doing so, Chief Justice, one has to have a very well-developed worldview in the judiciary. I am one South African judge who has networked with judges on this continent, senior judges, in a number of aspects. One of them I've dealt with as president of the Africa chapter. That has given me the opportunity to interact with the leadership of the judiciary, of the African Court itself, of the East African Court of Justice, of some of the jurisdictions like the Tanzanian Chief Justice and the senior members of that court. I have had occasion to meet with judges from Zambia, from Ghana, from Liberia, from Kenya. I have had that opportunity to interact with judiciary members in this continent to understand what they do. And I want to believe that this well-developed view of the African judiciary landscape will stand me in good stead, should I have the honor of being appointed, to bring that experience to bear in the deliberations that happen as we continue with the constitutional project of interpreting our constitution, in ensuring that the Bill of Rights, the constitution, becomes a reality in South Africa. Having said that, Chief Justice, my view is the Deputy Chief Justice must possess strong intellectual leadership skills to support and advance the constitutional jurisprudence development of the Constitutional Court. The Deputy Chief Justice, as supporting the Chief Justice, must have a very well-developed operational as well as a systems and administrative sense to ensure that the operations of the Constitutional Court and of the general judiciary goes according to plan and achieve its objectives and is efficient, right? That meeting that we had with the President recently, Chief Justice, which you led, the President has confirmed to South Africa that the independence that the judiciary has been calling for is going to become reality. That will bring more obligations and responsibilities to the judiciary. I mean, taking account of the infrastructure portfolio itself, it comes with a budget, it comes with staff. You need to have an OCJ that is well able to deal with that new responsibility and ensure that it finishes and starts new projects that we've been calling for and complaining about effectively. So the Deputy Chief Justice next to the Chief Justice must have these skills to guide these processes. I mean, President of the SCA sits there, has been doing a very good job chairing the Judicial Operations Committee, because that's the committee that's going to take charge of the operational footprint of the OCJ. And the DCJ supporting the Chief Justice will play a very important role in guiding how we deal with these additional budgets. As I said, at Legal Aid South Africa, I dealt with a budget of more than 2 billion. I'm subject to correction, but I want to think that the budget I dealt with as chair of Legal Aid South Africa, the board, is more than what the current budget of the OCJ is. But that budget of the OCJ will increase. And that comes with serious responsibilities. CJ, I say it without any fear of contradiction that the judiciary is society's true intellectual real estate. It is the arm of state that must ensure the continued confidence of society in our Constitution and the rule of law. And the Chief Justice, as the leader of the judiciary, supported by the Deputy Chief Justice, will execute this objective very ably. I want to also mention a number of focus areas that I think are important in what the Deputy Chief Justice will be responsible for. And I've separated this into 4 focus areas. These focus areas are expanding on what I mean by the Deputy Chief Justice supporting the Chief Justice. And this first focus area is supporting the Chief Justice's vision. The next focus area will be supporting an efficient Constitutional Court and judiciary at large. The next focus area will be what I term rule of law threats, which I think as a judiciary we need to be mindful of. And when we engage with the executive, we mention this because the executive and the legislature constitutionally must support the work of the judiciary. And where needs be, they must defend the judiciary where it comes under unnecessary and unwarranted attack. The last focus area deals with my own leadership track record, which we've dealt with a bit now. So I mentioned these focus areas, Chief Justice, simply to buttress the importance of the role of the Deputy Chief Justice. Chief Justice, you've hit the ground running as the current Chief Justice. Your vision is very clear, the independence of the judiciary. And hardly a year in office, the executive has yielded. We've been fighting this battle for the last 14, 15 years. But now it's going to become reality that we will also be institutionally independent. And as I say, the Deputy Chief Justice must support your role in ensuring that when this institutional independence becomes reality, we as a judiciary ensure that we use it to the betterment of South African society. Chief Justice, you are aware, and everyone else in this room is aware, that now and then, and on a rising, growing level, there are people who actually are suggesting that we don't need a constitution. There are people who are raising concerns about whether the constitution has delivered or whether a new dispensation is required. Those are important discussions, Chief Justice. I sit here as head of court well aware that yes, in certain parts of society, the constitution has not become reality. We still find pockets of abject poverty. We still find pockets of people who do not know the constitution, who do not know that they can effectively use the courts to their assistance. But you ask yourself, how can they use the courts if they don't have the funds to access courts? So that's the reality of South Africa. And as Deputy Chief Justice, should I have that honor, I have been very active in giving public speeches. I think in addition to speaking through our judgments as the judiciary, we must also engage with civil society to face criticism and deal with the issues that are raised about whether the judiciary has failed in ensuring that the constitution becomes reality. So on judicial independence, coming with the single judiciary concept, Chief Justice, that is bringing the magistracy on board, I think the Deputy Chief Justice will play a key role in assisting this vision to go in the right direction. The current document that we have in place that puts our position as a judiciary about what institutional independence we want leaves a remedial role for the executive, that is the Minister of Justice, regarding the magistracy. I think as a judiciary, we still need to grapple with that and understand what are the parameters of the continued role of the executive in the affairs of the magistracy. So the Deputy Chief Justice will play a key role in assisting that. The other part of your vision, Chief Justice, is capacitation of the judiciary. I mentioned researchers, but more so, there's an issue about judicial capacitation. Almost all courts require new judicial posts. The work of the judiciary has increased. Everyone knows that. But the capacity or the establishments that deal with this work has not been increased. Some of the things I've done in Gauteng is to go to the bar and to the legal profession to ask for senior members to avail themselves to come and do pro bono work, that is unpaid work, because it just is impossible to deal with the demands of the work that comes through with the current establishments. So I believe the Deputy Chief Justice will play a key role in supporting you, Chief Justice, in that vision of appropriate capacitation of the judiciary, not only from a judicial post point of view, but also from a support point of view. Appropriate researchers. I mean, the High Court of 43 people can't be meaningful in doing its work if it only has 6 researchers. I think that has to be looked at. That has to be beefed up to ensure that the constitutional project becomes a success, because judges well supported and able will be able to make sure that there's timeous hearing of matters and timeous handing down of judgments. Chief Justice, the Deputy Chief Justice is also key in supporting your overall vision of an overall transformation of the judiciary. You've been very meticulous in ensuring that we don't willy-nilly adopt a sexual harassment policy. That sexual harassment document is going through a number of phases, because it goes hand in hand in terms of transformation and the proper understanding of our dynamics as we work in the judiciary. So, Chief Justice, a Deputy Chief Justice will assist your vision in driving overall transformation, as well as the emphasis on advancing women, right? So the Deputy Chief Justice will have to understand that this is a key constitutional injunction, transformation in the judiciary. I have committed myself to the transformation of the bench. And if one looks at my track record as the people I've invited to the bench, the people who've been appointed under my watch, I want to believe that if I have the honor of being appointed, I will continue with that project of assisting the Chief Justice in this vision, Chief Justice. The other aspect that's part of your vision, Chief Justice, that needs to be supported is appropriate and adequate remuneration of the judiciary. Correctly so, you gave me the responsibility to address the President and members of the executive on this. The judiciary, as we speak today, the salaries of judges have regressed by not less than 34%. And that is the only part of the groupings dealt with by the Commission that has lagged so far behind. And the perils of this, Chief Justice, is if the judiciary is not appropriately remunerated, we don't come to the bench for money. That is correct. But we have lives to live. Some of us still educate children. We've got debt to service. It is implicit and important that the judiciary is appropriately remunerated. And Chief Justice, that's one of your vision issues that the Deputy Chief Justice will assist you. But the other one, which we've dealt with briefly, is continued modernization of the judiciary, Chief Justice. I've been fortunate that I've been central to the modernization of the judiciary in South Africa. Yesterday, I was talking to one of the OCJ officials about the Microsoft Copilot, about what this is an AI tool. And we have it, but I know that judges don't know it, don't know how to use what Copilot is. But perhaps my inquiring mind, and being the chair of the JAID committee, the IT committee, gives me these opportunities to think about and discover new tools of how we can work. So it is one of your vision issues, Chief Justice, that we must pursue modernization as far as possible. It was yourself, CJ, when you sent us the UNESCO document on AI, and you gave us a challenge to say, come with policies and guidelines about what the South African judiciary can do on the AI front. So on the court online case lines rollout, were I to be appointed Chief Justice, I will continue, with your permission, of course, to ensure the rollout of the case lines and court online. As we speak, 7 courts are live. They are now using that platform. We still have others. I want to believe that by the end of the year, the remaining courts will have gone live as well. I'm going to act in the Concord from 1 August. And I've told you, CJ, that I refuse to go back to paper. I'm going to do my appeals online. And I hope, Chief Justice, with your permission, I'll be able to entice other members of the Constitutional Court to start doing their work online. I mention this for this simple reason, Chief Justice. I've done research about what other appellate courts have done in terms of ensuring efficiencies in their programs. Nigeria, the state of Lagos judiciary, Brazil, India, US, Germany, Canada, and Kenya, and Ghana, to make a few, have introduced electronic case management systems in their processes, and they have reported serious efficiencies in their operations. So, Chief Justice, I will continue in supporting your vision. That's the first focal point. The other focal point that I want to talk about as to the role and my understanding of what the Chief Justice, the Deputy Chief Justice should do, is to support an efficient constitutional court and the judiciary at large, efficient in its operations, Chief Justice. The delays that one sees reported on matters get filed on particular days, but it takes so many years for those matters to be heard. And once they're heard, the delays that come with judgments not being handed on time. I think the Deputy Chief Justice will play a key role in engaging the heads of courts with yourself, Chief Justice, to understand the true reasons. One of them is support, I've mentioned it, but there are others. But focusing on the Constitutional Court itself, Chief Justice, I've done a research about what other appellate courts do to control their docket and to ensure they don't have backlogs. South Africa is the only court so far that has an 11-member, or I'll say 8-member bench that must hear and decide all cases. The international law is smaller panels. And I'm happy that this discussion has already started, led by yourself, of course, Chief Justice. But if you take India, India receives more than 80,000 petitions per year. It is impossible for that judiciary to deal with that type of caseload. But they've introduced electronic management, but they use smaller panels to deal with how they deal with applications for leave to appeal and hearings themselves. And throughout my research, the key considerations in the matters that deserve to be heard by the appellate courts, Chief Justice, are matters of a constitutional nature, matters of national importance, resolving conflicting judiciary pronouncements, just to name a few. Now, our Constitutional Court, every justice must look at the new apps, that is the petitions. And this is an incidence of the increase in its jurisdiction. Kenya, the Kenya Supreme Court is composed of 13 justices, but that court deals with its hearings in 5-member panels. And that enables it to push more cases through its system. The German Constitutional Court, it has 2 chambers of 8 justices each, and only 6 of those can participate in hearings. But in terms of petitions, Chief Justice, 3 of those 8 justices deal with those petitions. And once they've disposed of them, they don't have to capture the attention of the other justices. I mean, the US Supreme Court has what we call the rule of 4. It's an internal rule that that court uses to deal with new petitions. It receives more than 7,000 petitions per year, but it hears not more than 100 per year. And the way it does it is, anyone who wants to send a matter to that court has to apply for a writ of certiorari. That's what they call it. And only 4 justices are required to vote for a certiorari certification to be issued. If there's 1 or 2 that vote for it, but the others are not interested, that's the end of that matter. So I'm just buttressing the need for new thinking about how the Constitutional Court can do its work and deal with the backlog that it has of new apps. I don't like it to see that some judgments of the Constitutional Court are reported as taking 9 months, 8 months or so. It's not good. So, as Deputy Chief Justice, if I have the honor of being appointed, I will ensure that there is robust discussion at ensuring that a new way of how that court deals with its work is found. One other way that I thought I would suggest, CJ, and I mention it here, is the Supreme Court of Appeal. If you look at all the reports, it's a well-oiled machine. It functions perfectly. It has no backlog. That court, through the Superior Courts Act, is able to grant leave where the High Court has said no and remit that matter back to the full court to deal with that appeal. The Constitutional Court doesn't do that. You find matters where the High Court has refused leave. It's gone to the SCA has refused leave, has not had the matter, refused leave. Goes to the Court. The Constitutional Court finds that there may be an arguable point and grants leave and hears that matter. Why is it, especially where the matter involves the common law, why is it that the Constitutional Court should not be enabled to grant leave and remit to the SCA? Because in many judgments, the SCA, the Concord has said it will benefit from the reasoning of the SCA, especially in matters that deal with the development of the common law. So it's an idea I have. I think it's one of the aspects that can relieve the Constitutional Court of the load that it's carrying in terms of all the cases that it has to hear. So that's as far as the workload processing of the Constitutional Court is concerned. And as I say, my operational sense, which I've gained as chair of Legal Aid South Africa and visiting justice centers, engaging with stakeholders and understanding what critical issues are. I mean, when I visited Australia years ago, I discovered the High Court unit model. Previously, Legal Aid South Africa didn't have High Court units, that is, units that serve High Courts. And I came back and we discussed it to say it makes sense for each province to have a High Court unit where you have senior attorneys and senior advocates who do the work of the High Court. So, CJ, I'm saying this operational sense that I've gained will stand me in good hands in terms of, in good stead, in terms of assisting the CC, that is the Constitutional Court, as well as the judiciary in terms of dealing with their workloads. I mean, I've mentioned all the time that the turnaround times of criminal trials in the regional court leaves a lot to be desired. You can check any awaiting trial detainee report, you'll see that there are cases that still take 9 years, 8 years to be finalized. And these are people who are presumed innocent. So we need to put our thinking caps on, CJ, and deal with it. I'm not sure in terms of time where I am. I still have 2 focus areas.
1 minute left, as a matter of fact.
Chief Justice, I'm sorry about that, but one other issue...
You can round off, JP.
Thank you. One other issue that I thought I will raise is, Chief Justice, there are certain threats that I see are threatening our rule of law arrangements. One of them was mentioned by the acting DCJ on the 19th during the dinner where you're welcoming our international delegates to their 30-year celebrations. That is where powerful people criticize the courts with unsubstantiated cases. Powerful people who criticize the courts, who impute corruption and other negative imputations on the judiciary, are a threat to our rule of law. South African society is a gullible society. I'm not on social media, but I'm told about what gets said there about the judiciary. I think the Deputy Chief Justice should take up the mantle of supporting yourself, CJ, in engaging the legal professions as well as civil society formations in discussing and making them aware that this type of wanton, unfounded criticism of the judiciary is a problem. That's the one aspect. But the other aspect, which I think is a threat to the rule of law, Chief Justice, is there's a recent trend that has come up now where legal professionals come to court wanting to pick fights with judges. Not only does it end there, you've got a trend now of legal professionals encouraging their clients to lay judicial misconduct complaints against judges who rule against them. The JSC has a number of those. This amounts to intimidation of judges. It can't be allowed. It can't be that if I sit in a matter, I've got to check if I rule this way, will there be a complaint? If I rule this way, there'll be a complaint. I think this is an important issue that needs to be confronted and dealt with. So it is the weaponizing of the complaints mechanism against judges, and it is a threat to judicial independence, Chief Justice. A strong and independent judiciary is a prerequisite for our constitutional project. And there should be an independent and ethical legal profession as well, Chief Justice. I think another trend that I'll just mention is the growing trend of corruption in courts. And I don't want to be understood to be saying judges are corrupt. Chief Justice, you had to go to Mthatha because of media reports that said there was corruption happening in that court. It's not only in that court. I'm sure you remember a week or two afterwards, there was a raid by members of the DPCI in my court in Pretoria. I was fully aware that raid was imminent because I've been involved as head of court in discussions with the leadership of the courts as well as the legal professional bodies. Because, Chief Justice, there are members of the legal profession who are involved in this corruption, who benefit. And every time when you get these reports, you ask, I'm looking for names, I'm looking for affidavits. No, we can't give you that. We are scared. Scared of what? But that will undermine the rule of law, Chief Justice, if corruption continues. So I think it's a project that I think the DCJ should undertake to assist the Chief Justice. Because I don't have time, I wanted to talk about my proven track record as a leader, but I just need to leave this thought, Chief Justice. I have strong institutional experience at leadership level. I have experience in dealing with national budgets, as I said. I have been fortunate to be assigned leadership roles in the judiciary. I chair the Infrastructure Committee, JADE. I sit in the Remuneration Committee of the Judiciary. I think my leadership style, Chief Justice, is one of inclusivity, team leading, and enabling. Were I to be appointed or recommended as Deputy Chief Justice, I will continue in that leadership philosophy because I think it builds onto yours as well, Chief Justice. You have that way of leading people, that as leaders, we need to work together. I'm one person who recognizes that we are not equally endowed. There are judges who are smarter than me. My role as a leader is to get them to me so that we work for the common good of the judiciary, Chief Justice. One thought that I want to leave is, as a young member of the judiciary in 2012, I was invited to a judiciary leadership retreat by Chief Justice Mogoeng. That retreat came with 3 very important key issues that we implemented. One of them was judicial case management. You remember, Chief Justice, that in 2011, after the judges' conference, one of the resolutions was judicial case management. But there are heads of courts who opposed judicial case management. Heads of courts who said it's not a judge's job to get people along to agree and to get trial ready. There are judges who said their job is to hear matters. But we knew that these matters get packed in our processes and they don't move. We need to move them. That was one of the key resolutions of that retreat, Chief Justice. So I'm saying it's a thought that I thought I'll share with the Chief Justice to say the leadership of the judiciary in South Africa has evolved. We need to find each other as the leadership. We may benefit because in that one, Chief Justice Mogoeng had called judiciary leaders from other jurisdictions to come and sort of help us come to grips with our reality. I think the context may be ripe for us to have another retreat under yourself, Chief Justice, so that we find ourselves and we pull together. There are a lot of other things I can say, Chief Justice, but thank you for giving me this time to say this is what I see the Deputy Chief Justice role to be. Thank you very much.
Thank you, Judge President Mlambo, for that strong statement. And just to round off quickly, for my part, I forgot to mention one important item of your CV, the fact that you have actually acted in the Constitutional Court previously.
I did, Chief Justice, yeah, for 8 months in 2022.
And you penned judgments for that court during that
I did.
stint.
I penned 2 judgments.
Yeah. And as you have already mentioned, you will be returning to the court to act in the 3rd and 4th terms of 2025, next month.
Yes.
And we look forward to welcoming you back.
Thank you very much.
And helping us with cotton line and all these newfangled technological measures that, that give us, some of us, trouble. I just wanted to mention that I've heard the suggestions you make for the Constitutional Court in particular, and happily, it's measures that we have already started to put in place. And there is one important one you mentioned, the ability of the court to hear matters, consider matters that come before it in smaller panels, which requires a constitutional amendment. And we have a very cooperative Minister of Justice who has listened to our plea to make sure that this constitutional amendment takes place in the very short term, because the court is drowning with work. And that project is already underway. So hopefully, within a relatively short time, the Constitutional Court will be able to function as efficiently as the Constitutional Court, the Supreme Court of Appeal does, hearing matters in smaller, panels and not having everything clogged up for 11 people to decide. But we accept the encouragement. Now, lastly, from me, for now, a niggling issue. You and I have worked together and supported each other in this institution for a long time. So I know your work style. And you have made it very clear in the presentation you just gave now about the role of the Deputy Chief Justice, that you understand that role to be to actually support the vision of the Chief Justice, as work is done to run the judiciary smoothly, efficiently, and in a way that conforms with the constitutional mandate that is conferred upon the courts. But I still have to ask you this question, because when I was interviewed for the position I hold now, it was asked by a representative of the heads of court cluster, of which you were part even then, whether South Africa is ready for a woman chief justice. And I want you to tell us, me in particular, in front of South Africa, whether having been a head of court for 14 years, calling the shots, having other people, listen to you, if you would struggle, it would pose difficulty for you to suddenly find yourself working under the leadership of a woman who is younger than yourself. I know the answer you're going to give, but I still want it on record.
Chief Justice, I will not have that problem. In fact, I don't think it's an issue at all. You will recall that when you were recommended as Deputy Chief Justice, in fact, starting as President of the SCA, we had a discussion, and I supported you. I said, it's time, and thanks for accepting the role. And when you are nominated for Deputy Chief Justice and appointed, I phoned you, I congratulated you. When you are appointed as Chief Justice, I said, we vied for this job together, you got it. Congratulations, you can rely on my support. And I want to believe I've lived up to that promise of supporting you, Chief Justice. I don't see myself struggling with towing the line. I want to put it that way. I'm not in the judiciary for positions, Chief Justice. I'm in the judiciary to ensure that the judiciary fulfills its constitutional mandate in whatever capacity I find myself in. And I would gladly support you and work under you and abide by your dictates and directions, Chief Justice. I want to assure you.
Thank you, JP. And indeed, you have supported me fully in all my leadership positions in the judiciary, and I appreciate it. Colleagues, I don't know if you want to take the tea adjournment now, and then we can continue with the interview a little later. 15 minutes? What time is it now? 11:12. We come back at 11:30.
Good morning, JP Mlambo.
Good morning, President Mlambo.
How are you?
Could be better, thank you. I've known better situations.
JP, first of all, maybe I should just acknowledge in your presentation on your vision, you alluded to the fact that you have empowered a number of judges. I think I should just mention that I am one of those that you invited to act at the Labour Appeals Court shortly after you had been appointed as the Judge President of that court. I don't know whether you remember, you may not remember, but I was one of those, so I thought I should just, in attesting to the fact that yes, you have empowered a number of females, I'm one of those. I just want to touch on something that you mentioned in your vision about referring matters about the Constitutional Court, remitting matters to the SCA where the SCA had not previously dealt with the matter. I have absolutely no objection to that. It makes a lot of sense. I just want to hear your thoughts on this concern that I'm raising. And in raising the concern, maybe let me just allude to the fact that prior to the 17th constitutional amendment that ended up granting the Constitutional Court general jurisdiction, there was a consultation process. And during that consultation process, a number of bodies and a number of courts did caution that it could cause bottlenecks in the processes. And eventually the amendment was granted and the Constitutional Court was granted general jurisdiction, and the bottlenecks and the delays that had been anticipated did materialize. And some comments are to the effect that the amendment was done, but the concerns that had been raised were not taken into account before eventually amending and giving the Constitutional Court general jurisdiction. Now, you have stated that you would advise the Chief Justice and your colleagues at the Constitutional Court, if appointed, to remit some of the matters to the SCA, and alluded to the fact that it is a well-oiled, the SCA is a well-oiled machine and has no backlog. It's a compliment to the court, and I thank you for the compliment. But I must just also caution that, as you know, the general complaint from all the heads of courts is that the capacitation of the courts in terms of judicial appointments is inadequate. So in other words, every single court has an inadequate number of judges considering the workload of the court. So my caution would be, and I want your comment on it, would be to say before implementing that, could you please then ensure that the SCA is capacitated in terms of the number of judges, because that stance obviously will increase the workload of the court, which has always been increasing over the years because generally the workload in all the courts has been increasing. Your comment on that, please, JP.
Thank you very much, President Madamela, and thank you for your acknowledgement of whatever little role I've played in your career development. I remember when you were sitting with me and JP Japi in the LAC in KZN, we were minded to go in a different direction, and you persuaded us in your very first sitting to say, you guys are wrong. And we said, come with the draft, and the draft persuaded us we were wrong. So I thank you for reminding me of that aspect. President Mlambo, you're correct. I think the capacitation of all the courts is an issue. We have the report from retired Deputy Chief Justice Moseneke as heads of courts, which makes a certain recommendation about judicial capacitation. So, yes, I can understand your concern that we should not bedevil the Supreme Court to start developing a backlog when it starts receiving those matters. My overarching view is, President Mlambo, it will not be me imposing a thought. I think this will be subject to discussion by the Chief Justice leading us to say whether she agrees with this way. Because right now, there's an amendment that's being mooted by the Chief Justice that's sitting with the executive, I think, in terms of introducing smaller panels. I've not seen the amendment or the draft amendment, but my understanding is that that amendment only deals with the Constitutional Court dealing with new apps in smaller panels. I don't know whether it translates to also hearing matters. So I see the CJ is shaking her head. So
No, I wasn't shaking my head. It does.
So, yes, I think the judicial capacitation is one of the issues the Chief Justice is pushing, that courts need to be properly capacitated to deal with the work that comes. And I don't think one will be reckless in adopting any measures that could render another court dysfunctional. You're correct, but it feeds into what I've said to judges in the High Court. During the apartheid years, when common law still reigned supreme, the divisions in their full courts created law. And that was where matters ended. When they went to the appellate division will simply refuse leave, which is what is happening in the US Supreme Court. the US Supreme Court only intervenes very sparingly, and it's only when there's a divergence in views coming from the federal appeal courts. But the appellate division would intervene if the case law coming out of the different divisions was contradicting each other. They would intervene. So I'm coming to the point that I've said to judges, why are they so quick to grant leave to the SCA and not grant leave to the full court of the division? Because that way, it enables a matter to be adequately dealt with at divisional level, so that once it's heard by a judge and then 3 judges, when it goes to the SCA has the benefit of those 2 judgments, and then it can decide whether it hears that matter or not. And I'm not sure that it's a matter that will be willy-nilly appealed from going forward from the SCA to the CC. But I'm happy to hear that you have no objection. You find that there's merit in my suggestion. And I think the CC has said so in a number of judgments. I mean, the Commission judgment is one where the CC remitted the matter back to the High Court because I think there had been an absolution from the instance order granted, if I'm not mistaken. So the CC said it's not a court that deals with factual disputes and stuff. It must go back to the High Court to be dealt with. But if it has to do with the development of the common law, I think the SCA is well placed, better placed to actually deal with that matter before it goes to the CC, if it goes there. Thank you, President.
Thank you, CJ. You are being interviewed at a very exciting time for the judiciary, considering that an assurance or a commitment has been given by the President of the Republic that the steps will unfold within 6 weeks to give the judiciary the institutional independence it has been seeking for the longest time. That is very exciting indeed. And what is well known is that the judiciary has been under-resourced for quite some time. And I do not imagine that the first thing that is going to happen once we have judicial independence is that we will all of a sudden have sufficient resources. Now, the judiciary has been fortunate enough in the sense that there have been bodies that have been willing to come to its assistance in as far as the challenges that it is facing regarding the resources. Now, my question to you is, if the judiciary is to accept financial contributions or donations from third parties, there would obviously have to be a policy that allows us to do so. If you were appointed as the DCJ and you were asked to develop that policy, what steps would you take in terms of ensuring that the process is transparent, in as far as everybody knowing that they may, if they so wish, contribute, and what the parameters are in terms of the acceptance of contributions from third parties? Please let me know if my question is not clear.
I understand the question,
Thank you.
President Mlambo.
Thank you, JP.
Thank you very much. I sit in the fortunate position that I and JP Toba Boyohlwati, JP of KZN, were tasked with the responsibility of providing a policy, I would say policy statement, I won't say policy document, to the heads of courts about how to deal with donations from third parties. So we provided a document to the heads of courts. It's still under development, but the issue is we've got to be extra careful as a judiciary when we accept donations from the private sector. I mean, that's the underlying principle in the document that we developed, and I maintain that stance. We can't accept donations from people who are tainted. who may feature in our courts as litigants. So the first thing I would do is to make sure that serious caution is exercised, and the document needs to spell it out as to where are the funds coming from, and does that entity have any history in terms of whatever has gone wrong in this country, malfeasance, if I may use that word, and what are the parameters of how we accept, whether we accept money or we accept services. And let me give you an example. In Gauteng, we have the Phineas Mojapelo Continuing Education Center. It's a state-of-the-art training center. We asked for money, we didn't get it from the OCJ. So the GCB, or the Johannesburg Society of Advocates, understood our plight, and we set up a trust committee to say we have needs. But what we don't want you to give us money. And we don't want to hear any discussion about money, about amounts. All we'll tell you is we need a training center. Please assist us in developing that training center. We have a training center. We don't know how much it cost, and we don't want to know how much it cost. But we accepted that assistance because professional development of the judiciary is key to us continuing to do our work. 2, we've accepted other forms of assistance from the JSA. I mean, you could simplify it by saying, when I go to an advocate and say, come and act pro bono, I'm actually asking for assistance, right? So we felt that that was a clean way of accepting it. So I know I'm giving a roundabout answer to your question, but I'm saying, I'm just emphasizing the issue of caution. And you mentioned the other one, transparency. Were we to adopt a policy of that nature, we can't adopt it and hide it. We need to be transparent, right? People who are users of the court need to know that the judiciary has this policy. And if we've accepted help from wherever, that needs to be disclosed in our accounting documents that we publish, so that people who interact with the courts know the judiciary has accepted acceptance, and that the assistance, and that assistance is going to doing that or that or that. I think that will be the very first and important task. Thank you, President Mlambo.
Thank you, JP, for that comprehensive response. Thank you, CJ.
Thank you, President. Minister, are you ready now?
Thank you very much, CJ. Good morning, JP Mlambo.
Good morning, Minister.
You alluded to quite a number of issues that relates to access to justice. And you reflected around where people are starting to say in our communities, perhaps the constitution is not working. And also, you articulated that this can be understood in the context of poverty, but also just in terms of the cost that is associated with access to justice. In your comment, you say perhaps what is important, and also another issue that I would link to that is where you talk about the attack on the judiciary. Because in two of those instances, you are reflecting on the need to engage civil society as part of making sure that they understand what needs to be done. Perhaps, if I may say, if we look at various areas where you'd find some of the attacks, they would not be necessarily even from civil society or ordinary South Africans. And I think it could be my wrong view, and you can correct me. You shied away from mentioning that it is from political parties that you find the attack to the judiciary at most of the time. And my question would say, in that working for ensuring that we could see access to justice increasing, but also addressing the issues, how do you see the interface between the judiciary and political parties in the country, and to ensure that we are able to find each other in a single system that is in the best interest of South Africa?
Thank you for that question, Minister. One straight answer would be that engagement that the Chief Justice led us to meet with the executive is what I think is necessary. I did shy away from mentioning political players in the criticism of the judiciary, but I want to believe that the judiciary is an arm of government. And in terms of building committee with other arms, it's necessary periodically for the leadership of these three arms to come together. And it is in that gathering that the judiciary may express whatever concerns it has coming from the political arena. Because once you raise it with the leadership of the executive, right, or with the leadership of parliament, the legislature, you expect that whatever concerns you've raised will translate there, and whatever concerns that are raised against the judiciary will be fed back to the judiciary. I think that's one sure way that I think I can mention that can deal with political players who may be unhappy and who may be found to be criticizing the judiciary unnecessarily. I mean, one example is, you will recall, when the al-Bashir judgment was handed down, such an engagement happened. The president of the country at the time and the Chief Justice, with their respective teams, met to discuss that fallout and to call caution, to say, look, South Africa has international obligations, and the court, when it's confronted with a case that says, force government to comply with its international obligations, you can't then have political heavyweights calling judges counter-revolutionaries. So I'm saying that's one aspect that one can use to diffuse these things at that level, because you can't expect the judiciary to respond to individual statements coming up, but that engagement and can go a long way into diffusing these situations. That would be my answer to you, Minister. Thank you.
Thank you very much, JP. Another area that came strongly in your presentation is the issue of, as you were outlining what you have done in terms of your work and your career. It's around the directives that you have issued in terms of managing the caseload. And you've acknowledged some of the challenges that leads, or some of the experiences that leads to, either in criminal or civil matters, where you find that people are not finding dates in time. Maybe perhaps just to understand, and this in several times and continues to be challenged and within your ambit, if you could take us through what has been the benefit of this process. There are those that believe that this process is likely to benefit those that have money or that are able to negotiate better. Those who have big law firms that can negotiate, and therefore ordinary South Africans might find themselves in the back foot and not being able to negotiate better in terms of those directives, and can find themselves not having justice in civil matters that they bring before the court.
I don't know if you want to answer that question, Judge President Mlambo, considering that the matter is sub judice.
There is the matter is being litigated,
Yes.
Minister. So I don't know whether you want me to answer it, Chief Justice. I can give a general response.
All I'm saying is that it's being litigated. I leave it in your hands to decide whether you want to address it or not.
It has been decided already.
Has it? We may be at cross purposes. But I thought she was talking about the matter that has attracted a number of, of applicants seeking to challenge the directive you issued not so long ago.
I think the nub of the minister's question relies on that, but I think she wants a general answer. What has been the benefit of directives? That's how I understood the question, unless I'm mistaken.
Just tread carefully there.
Thank you. Thank you, Chief Justice. Minister, one aspect that I think needs to be debated in a retreat of the leaders of the judiciary is the taking away of the power of heads of courts to issue directive to address local dynamics. As courts, we've got different dynamics. The Supreme Court Act had a provision that gave heads of courts that power. That power was taken away in the Superior Courts Act. And that power was just given to the CJ, but to issue directives regarding case management and whatever. Now, I think it's important because when you are a head of court, you are confronted by dynamics that apply to you only. You can't sit back and not do anything. You need to look at the process flow and with the objective of balancing, like you mentioned yourself. There are big law firms that were dominating the unopposed motion court when I took over. You find that there are 25 matters from one law firm in the judge's role. And you find that the small firms get pushed away, right? And then they had to wait long because the big players are actually dominating that space. Now, when the rules are silent, what do you do as a head of court? You need to balance the playing field, isn't it? So, whatever directive I have issued, Minister, is a directive that is informed by the reality on the ground, by the need to promote access to justice to all in an equal manner. So I think I can give you that general answer, Minister, to say that each directive were not issued recklessly. There was a well thought out position, and some of these directives are a product of divisional meetings where judges as a division meet and discuss, led by those committees that are leading in those work areas. So it's not like it's my decision alone, right? So maybe let me stop it there. Thank you very much, Minister.
Commissioner Tsipanenson, did you raise your hand?
No, thank you very much, CJ. Good morning, JP.
Good morning, Chair of Chairs.
I'm not chair of chairs, JP. JP, coming from outside the Constitutional Court, how would you establish credibility among colleagues who have longer tenure at the Apex Court, particularly in managing the internal judicial processes or disagreements?
Thank you for that question. I want to believe that there's an internal committee in the judiciary about collegiality and respect for each other. And I don't foresee any problem whatsoever in colleagues in the Constitutional Court taking up a position that you're not coming from here, therefore you can't lead us. I'm not sure if it would be any responsible position to be taken by a colleague. We are all judges and we are all coming with experience at what we've done as judges. But one thing that I need to mention is Chairperson, I have written in diverse constitutional law issues, in case there's any doubt in anyone's mind of my judicial exposure to constitutional litigation. I have that. And that should be enough to allay anyone who wants to rely on the fact that I'm not from that court. I have written those judgments. A majority of them have been upheld by the same court that we interpreted the Constitution correctly. So I want to think my experience coming from wherever I am stands me in good stead. And having acted there for 8 months, in one matter, I didn't command a majority. In one matter, I commanded a majority. There is in another matter where I was part of a dissenting panel. So I am sufficiently independently minded to be able to do my work in the Constitutional Court. And I don't think there would be any qualms about that. I hope I've understood and answered your question correctly.
No, thank you very much, JP. I think you have answered me to my satisfaction. And I must also indicate, JP, your dedication to social transformative justice is truly commendable. And you also outlined the important responsibilities of the Deputy Chief Justice, and amongst others, you emphasized his or her role in managing court affairs, supporting the CJ's vision, facilitating judicial cohesion, and driving transformative change within the judiciary. In relation to what you have alluded to earlier on, how would you then describe your leadership style as a number 2?
Thank you, Chair, for that question. As a number 2, it would be consultative. I would consult my leader whenever I have new ideas about anything. And I would consult my leader when I see some other development somewhere, and to understand what her take is and what she would want us to do to address that. That's one aspect. Consultative. Inclusivity, I've mentioned. I have an inclusive way of leadership that I take people along with me. I don't do things because it's Mlambo saying this, right? As well an enabling environment that I want to create around myself, that I want colleagues to have the confidence like they've done in the division. Whenever they have issues of any nature, personal or professional, they know they can simply walk into my office and we can talk and we can resolve. So I regard my role as an enabler. But the important part, and that goes back to the question the Chief Justice asked me. As a 2IC, you can't be a loose cannon. You need to understand there's a leader of the institution. Even though there may be instances where the Chief Justice will be away and the Deputy Chief Justice acts, it doesn't mean that that Deputy Chief Justice is at large to interfere with the program of the leader. It's a consultative role more than anything else that second in command has to be acute to and aligned to. I think that's how I would answer the question.
Thank you very much, JP. Thanks, CJ. I have no further question.
Thank you, Commissioner. Commissioner Mugwetho?
Thank you, Chief Justice. JP, I just have two sort of broad lines of inquiry, not necessarily questions, but just to get your philosophy as the potential Deputy Chief Justice. And I was very pleased to hear in your presentation that you highlighted the problem of poverty and inequality that bedevils the creation of the new South Africa. Now, as the Deputy Chief Justice, how do you see the role of the Constitution in addressing the economic inequality in South Africa? There are many theories of what a Constitution does. One of them is that it's preservative. In other words, it preserves the rights that exist at the time of its adoption. The other is that it's transformative. It seeks to rupture the existing relations, particularly around property, which is a defining feature of wealth inequality. But it's a contentious topic about why do we have so much inequality and so much poverty despite an apparently progressive constitution? So that's the first area I would like your views on, about how do you think, as a Deputy Chief Justice, you will theorize the transformation of the economy through the lens of the Constitution?
Thank you very much, Commissioner Ngugaitobi, for that question. I think in one of my previous speeches, I've confirmed the statement you make that we adopted what is called a progressive constitution that seeks to uplift the plight of people. I've got people who represent legal formations here, because one way in which the Constitution can be used is to target particular bottlenecks that are continuing to confine South African people to inequality and poverty, to identify those particular bottlenecks and then bring carefully crafted litigation for the court to grapple with and ensure that the Constitution is applied to deal with that bottleneck. Commissioner Ngugaitobi, you know, the issue of Rule 46A has been raised by a number of judges as a problem, in the sense that that is the rule that is used by powerful players like the banks to further take away their property, especially their houses. One aspect of it that has been mentioned is the issue of substituted service. To say, in many instances that judges have come across, the first time a hard-pressed defaulting bondholder knows that his or her house is under threat is when the sheriff knocks at his or her door. There's something wrong. There's a misalignment somewhere. You should be the first to know that someone is taking action against you, and you should take up that opportunity to see how you can negotiate. But as a judiciary, I think we need to find a way of reforming these legal rules that form part of this conservative legal culture that we've built in South Africa, that dismantles that conservative legal culture and understands the plight of people to whom the Constitution applies. So I've identified that, but I go back to my initial answer. It is a very contentious area because the haves are always eager to litigate, and they have deep pockets in terms of litigating. But the people who may want to attack particular areas don't have the money to do that. Let me give you another example, and this relates to land. In the early years when I was still at Legal Aid South Africa, we dealt a lot with people who were given land but didn't know what to do with it. And I say that advisedly because those are the reports that we got in those gatherings. Now, land is a very important facet of a person's human dignity. This is my land. I can build on it, I can live on it. But if you come from a system that has relegated you to a non-entity, that has blocked you away from knowing how to use land, how to access finance, right? You will find the example you get on people getting RDP houses and selling them and going back to live in shacks. It's a deep societal problem. So that one doesn't answer your question, but I think the executive needs to be alive to these realities, to ensure that in its programs, it factors in the enabling requirement in what they should do in assisting people come to terms and actually take the right action. Now, I mentioned the issue of identifying bottlenecks. We have a number of legal professional bodies, and I've said to them in my speeches to their AGMs, why don't you create a legal fund? And I give the example of Thurgood Marshall, Justice Thurgood Marshall in the US, when he was a lawyer of the NAACP. He realized the NAACP has no money, but there are a lot of social transformative cases that he wants to take that can be funded. And they allowed him to create a fund, a legal fund, which would fund this litigation. And he was successful. So I use that example, and I want to use it in answer to you partly to say we've got organizations in this country that can establish those funds and that can interact with societal formations or with communities. I chair CAUSA, which is a grassroots access to justice level, and the needs for legal services is very big. So through those funds, I think critical areas like those you've mentioned can be funded from deep pockets to make sure that the Constitutional Court is actually challenged to develop the Constitution in the way the Constitution was conceived. Let me stop it there.
Yes, thank you. I mean, suppose primarily what judges do is to interpret the statutes or the common law or the Constitution, but in a given case. But that interpretation can hinder access to property by disadvantaged persons. But then the only way the judges can do that is to be conscious every time they interpret the Constitution what they're trying to do. In other words, are they trying to rupture the existing economic relationships? Or are they trying to preserve them even unconsciously? And that is where I think I always have a difficulty, is that you get a judgment that is worded in apparently neutral terms, but its impact is radical in preventing black people from accessing property. Because at the time the case was argued, just no one thought about the implications, because everyone thought, let's apply the rules. But they have forgotten that those rules developed in a socio-economic context of
Yes.
marginalization. So I just want your view on that issue of that sort of intellectual awareness that the law operates in a social context, but that context is to be sort of broken by this new constitution.
That is a function of conscientizing the judiciary. One of the judges we have appointed in Gauteng is extremely radical. But if you listen...
I don't want to know the name.
But he's radical in a positive way.
Oh, I see.
Because he's challenging us, who've been there for 20 odd years, to say, you've been here, and this is how you've been interpreting the law. You've sold out. That's the language he's used.
What do you say to that when they say you sold out?
Well, selling out is too strong to put. But Commissioner Nkukaitobi, you know, we have educational problems where judges are exposed to training if they're going to sit as equality court judges. I want to think that training can be embedded deeply for judges to actually understand what is it that they are going to be dealing with on the equality law front, not just process. It goes deeper. So social awareness, you know, and equality awareness, the past will come. I mean, that judge that I mentioned said to me when I said, but you didn't put your name forward to be trained on equality court cases. He said, no, a white man won't tell me what apartheid did to me. That's a very profound answer. So I think we need to embed more of these training sessions that actually challenge us and actually enables new incomers to the bench to actually understand. Because generationally, maybe we have sold out in being conservative and in interpreting things in one way, right? So I think my answer is that there needs to be this continuing engagement. And, you know, when I interact with colleagues in the continent, because some of them are more conservative than us, I'm sure you're aware of that, and ask, but you guys, you unshackled yourself from colonialism years before we did, but we've advanced further than you. Why? You know? So it is this conservative legal culture that I mentioned that's shackling us. And once we admit it as the judiciary, then we are well on our way to interpreting the Constitution in the right direction.
And then just lastly, JP, on the issue that you've dealt with, I think you gave the judgment in the competition court, although it was about jurisdiction in the Group 5 case, where you were in the minority. Regrettably, you agreed with me, but you were in the minority, so it didn't really help my client. But there's something important about that, which is you're talking about a conservative legal culture, and competition law is a particular area where this conservative legal culture plays itself out, and where the Constitution is playing a catch-up game, and there is no infusement of constitutional values within the interpretation of that statute called the Competition Act of 1998. And I want to single this out because if you compare it, for instance, with labor law, the judges are quite happy to infuse labor law with constitutional values. Or you compare it with land law, they're quite happy to infuse land law with constitutional values. But they are extremely reluctant to infuse competition law with constitutional values. Can you just articulate that for us and explain what your approach will be to that particular statute? And I ask this deliberately because you've got experience in it. You've written a judgment on it. You've had the debates on both sides.
I think, let me repeat, it's the conservative legal culture. And before I answer that one, there's another one that you're not mentioning. It's the Standard Bank case. As the leadership of the bench, we realized that the big players with deep pockets were actually using the current legal processes to actually disable vulnerable people. Because Pretoria has jurisdiction in Soweto, they could issue process against a Soweto bondholder in Pretoria. For that person to go to Pretoria, he or she may need to catch 3 or 4 taxis to get to Pretoria. That's one. 2, we said, but this claim is in the jurisdiction of the magistrates court. Why not issue this thing in the Soweto Magistrates Court, where this litigant is located? And we issued a Rule 16 notice and invited people because we knew what we were trying to solve. But legal culture trumped us because the SCA said, no, you've got inherent jurisdiction. And inherent jurisdiction is an incident of the common law. It says the High Court has inherent jurisdiction. But we understand that. We've got inherent jurisdiction, but we say, despite that jurisdiction, let's understand the realities that we have now, that this inherent jurisdiction is leading to injustices. The SCA told us to get lost, and the Constitutional Court told us to get lost. So in Group 5, it's the same thing. Co-conspirators of Group 5 went and pleaded guilty and got fines on direct competition law issues. And Group 5 decided to say, no, the High Court has jurisdiction, simply because they want to bypass the tribunal. which is the body that is properly capacitated to deal with competition law issues. I went out on a limb on my own because I believe that I was correct. And you can talk to the chairperson or the JP of the CAC now. The effect of the majority of the Group 5 decision is that the tribunal is now routinely bypassed. And I don't think it's an unintended consequence of how we decide these cases. But I think to actually interpret the jurisdiction of the High Court that strongly, to say you can actually give it jurisdiction in such a way that it makes inroads into the competition arrangements that give that jurisdiction to competition law bodies, it's a problem. Thank you very much.
Thank you, Chief Justice.
Follow up, CJ.
Thank you, JP.
And that was 3 questions, Commissioner Ngoito.
Three questions.
Commissioner Marubakhai.
Follow up, CJ, on that one. Good afternoon, JP.
Good afternoon, Prof.
I just want to pick up on the Group 5 discussion that you had with Commissioner Toby. I mean, I don't agree with the majority in that decision. I agree with your outlook because those competition law authorities are there to do a particular reason, and of course it will help the High Court to reduce the workload in the High Court. But there is a further argument that arises from the competition law cases that have been decided by the Constitutional Court. There is a view that, and this view it's quite surprising because there is general acceptance that the Constitutional Court can deal with the Labor Appeal Court's issues quite well. But there seems to be this view that the judges of the Constitutional Court do not have expertise in competition law matters. And because they do not have expertise in competition law matters, the final say in competition law matters must be the CAC, which last time I checked, it had a status of a High Court, so it not have a status similar to that of the LSC. What is your view on that aspect?
There may be merit in saying the CAC should be the final arbiter, but it is a court that is subordinate to the Constitutional Court in terms of the current legal arrangements, the opening up of the jurisdiction of the Constitutional Court. I'm not sure how to deal with that because there's merit in saying tax law, competition law, you may need to be properly enabled as a bench to grapple with these matters and actually understand what is meant to be done in terms of this competition law legislation. It may be a function of further training, but I think one aspect is probably to embed competition law experience and expertise also in that court. I think it would be one way of addressing it. Similarly to tax, but maybe I caution myself. Labor law. The Constitutional Court has given very progressive judgments in terms of supporting the LAC, in terms of developing the LRA. So if the Constitutional Court is able to do that in the labor law field, what about this? But look, Prof, the newcomers that are on the bench now never had the benefit of practicing in these areas, like competition law. So maybe that's one of the issues. I don't know. But I hope I've answered your question. Thank you.
Thank you very much, JP. CJ, I had other questions. I'm not sure, should I wait my turn or should I just pose them?
I was going to call you next.
Oh, thank you. Thank you. JP, you, apart from your labor law expertise, some of us respect you for your international law and refugee law contributions. And I think the lawyers who are practicing in those areas of law will be much happy should you be given the opportunity to get this work. When we look at international law, the Constitutional Court has been heavily criticized in how it has dealt with cases that deal with international law in particular. For instance, when one looks at the Glenister case and the SADC tribunal case, where the court was criticized for not grappling or misunderstanding the methodology of international law. Should you be given a chance to be part of that court, what role, if any, can you play in order to assist in developing or assisting that court to develop the South African jurisprudence in as far as international law is concerned?
I'm happy you mentioned refugee law. You see, the Chief Justice wrote a judgment called Ashebo. I'm sure you know about it. I happen to sit in a full court where I penned a judgment called the Lembore judgment. In social formations, those judgments are regarded as conservative. Why? Because for a long time, our law was, if you enter a foreign national as a law enforcement officer, say, you are illegal. You say, no, I want to apply for refugee status. The law said, don't touch that person. Don't arrest him, let him go. Ashebo arrested that. Says, no, no, no. We are relegating some critical legislative enactments that enable law enforcement agencies how to deal with these things. So, unfortunately, I'll be unpopular in saying there's a lot of idealism that goes into some of these judgments that come from our courts. And I call it misplaced idealism. I know I'll be criticized for saying this. We want to be everything to everyone. Judges in Uganda confronted me, say, you guys in South Africa, you're giving problems to us here in how you're interpreting international refugee law instruments. Because we've got a particular way in which we understand where international law is located. But you guys in South Africa, you simply say the Constitution, the Constitution, the Constitution. And that's the issue, isn't it? True, the Constitution is the supreme law of the land. But I can tell you as I sit here, I've read some of the judgments where properly reasoned international law judgments have been displaced by our courts to say constitutionally that judgment doesn't go far enough. Our Constitution demands the following. So I think we need to take idealism out and understand how law internationally has been interpreted and to what purpose, and understand what the purpose is. And then when we sit, I mean, the issue that Ashebo grappled with was the court in an earlier judgment had said, if you arrest and detain an illegal foreigner for being illegal in the country and for being illegal for years in the country, you are interfering with the non-refoulement principle. Detention has nothing to do with non-refoulement. Maybe I shouldn't say that because there's a case that comes from the Western Cape that has said that. So maybe I'm disabling myself from sitting in that case because they've referred it to the Concord. But international law is clear. It's deportation that is at the center of the non-refoulement principle, not detention. So I know I'm going around the belt, but I'm just saying, as a judiciary in South Africa, and I think the role I think I'll play, if I have the honor of being appointed, is to actually carry colleagues along in understanding that have been around. I've seen judgments of the European Court of Justice in terms of how it's interpreted refugee law instruments internationally, right? And to say, why should we very quickly find an international, a constitutional ground to disable international law that is specialist and applies to that particular area? That's the most I can say. Thank you.
No, thank you very much, JP. And I think it is something that really must be taken seriously because there's been a serious academic criticism of the Constitutional Court in international law. But my second question is more of what I think is a revolutionary act that you have done of allowing academics or giving academics an opportunity to be part of the bench through acting appointments. And not only that, but seeing them through, some of them, to actually being appointed as judges. My limited research, I'm not really sure, and I stand to be corrected. I'm not sure if there is any bar in preventing academics from acting as judges, not only in the High Court, but also the Supreme Court of Appeal and the Constitutional Court. Should you be appointed, what role are you going to play in ensuring that that sector of the legal space is actually, President Mlambo just said now that the Supreme Court of Appeal is short of judges. What role can you play? Are you still going to be on that trajectory of saying, but these are other people that you can actually tap into, and I've used them before, and they have delivered? What role are you going to play in that regard?
It's a function of engagement with colleagues, Prof. We have annual SAJ gatherings. The CJ knows, I've mentioned this to her before, to say, I'm happy that in recent times, I've seen more Constitutional Court justices attending these sessions. Because what SAJ has done is to rope in international judges to come and be part of that week. And they choose particular areas where they have expertise, just to broaden our scope as a South African judiciary. Because, I mean, in the past, the South African judiciary was quick to say, if you don't have any local authority, then go to the north, Canada or England or the US. So I want to believe that academics, they cast their net very wide in terms of what they do. The only thing you have to do as a judge is to recognize their expertise. I ask, this is your expertise. Can I put you there, or do you want to go into other areas? Especially if you want to become permanent in future. It's in your interest to have experience on a broad level. But academics bring that breadth. You see, their unchecked independence is very good in terms of saying to us, judges who are products of a conservative legal culture, that's not the only way you look at things. There is another way of looking at things. But in terms of academics acting in the, I'm sorry if I use the term academics, it may be viewed as derogatory, but I find a lot of value in them because nothing prevents me legally from appointing them. In the SCA, I think there's a legal prescription that's against that. The president can correct me if I'm wrong. I think that's why they've never been appointed there. But in the Concord, nothing prevents them being appointed to the Concord. We have good experience. The late Justice Yvonne Mohoro came from that rank, isn't it? And she's not the only one. So I think as a judiciary, we stand to benefit from harnessing all the skills and experience we can find around us to ensure that we develop good jurisprudence about these issues. Thank you.
No, thank you very much, JP. And the reason I mentioned Supreme Court of Appeal and the Constitutional Court is those courts sit in panels. So whatever damage that it is thought that academics can do, really they will be reined in terms of the system. That's why I raised those particular courts. Thank you very much, CJ.
Commissioner Moimang.
Thank you, CJ. Good afternoon, President Mlambo.
Good morning, Commissioner.
It's just one from my side, which emanate from the point you raised around capacitation of the judicial establishment, and you correctly made reference to the recommendation from Moseneke's team the rationalization process. But there's an area that I want to tease JP on, particularly in relation to access to justice. I suspect your referral to Sowetan that has to travel, to use 4 taxis to get access to justice it's an area that was also of interest to me. The committee, the Massachusetts committee, also make some concrete proposal on the rationalization, particularly the recommendation on the Eastern Cape, that the seat of the Eastern Cape Division be moved to Bisho, which is the capital of the province. I want to get a sense from you in terms of your view on that, because it is quite important, because the work is informed by the legacy of apartheid, because with both the interim constitution and the final constitution retained not only the seats of higher courts in South Africa, but also of the TVVC countries, which meant that many of the communities in rural areas must travel long distance to get access to courts, and it's also expensive. So I just want to get a sense from you as to whether, as an aspirant DCJ, what's your take on that other aspect of the Mosenegas team? I believe that as the Judge President, you also made some recommendation in relation to Gauteng. What's your take on that? Thank you.
Let me say this, Commissioner, thanks for that question. I first confronted that reality when I was chairperson of Legal Aid South Africa, when I was going around visiting the justice centers we have there, right? In Grahamstown, it's called, I forget what the new name is, and forgive me. Makhanda, yeah, in Makhanda. And then going to Gqeberha, and then going to Bisho. King Williamstown, I don't know what the new, is there a new name for King Williamstown? Konce. Thank you. So, I say, from an institutional point of view for Legal Aid South Africa, if you have a justice center that's servicing Mdantsane cases go to Bisho, but East London cases don't go to Bisho. They go elsewhere. At that time, I said there's an anomaly here. But the division was Mdantsane is black, East London is white. That's why there's this differentiation. And when I tried to tease the issue, I think the late JP Sangone was a JP at the time, to raise with him. He said, look, that's a hot potato, seriously hot potato. Now, I'm not from the area, and I say that up front, right? I think the people of the Eastern Cape needs to address this issue. You can't have Gauteng. I've got 2 seats, Johannesburg and Pretoria, and I've said we need to have local seats in Palm Ridge, and I've asked for a local seat in the West, because a lot more litigation that comes to Johannesburg comes from the west of Johannesburg, a lot more of it. Now, you recognize that access to justice demands location of justice services where the people are. That's the overriding principle. So, you're throwing a curveball at me by asking me what my take is. I think the recommendation is there. As a judiciary, we need to express our view. We still haven't wrapped our heads around it, especially being led by the judiciary in the Eastern Cape, about how to deal with this issue. Consultation has happened. Maybe it needs to happen more, because there are seriously involved self-interests that seek to preserve the situation as is. Now, I don't know if there's a space for self-interest in deciding where justice services should be. I think that's the general answer I will give you. I don't want to get embroiled into a seriously localized issue. Thank you.
Thank you, JP. Thank you, CJ.
Commissioner Matolo Dlepu.
Thank you, CJ, and good day, JP.
Good day, Commissioner Matolo.
I think mine is, I want to hear your comment. It's a follow-up from what Advocate Ngogaitobi was asking you about. And you said there are people who are worried about the constitution that is not working for them. I just want to hear your comment to say, do you think the judiciary is doing enough to dismantle the Roman Dutch law? Because that's what people are complaining about. And if we have to do that, what do you think the role of the judiciary could be? Because the judgments that comes out of the courts are the ones that the public is complaining about. Thank you.
I mean, my immediate question, thanks, Commissioner. My immediate answer is not enough of those cases are coming to the courts. Section 39(2) of the Constitution is clear. You say Roman Dutch law, that's common law. The Constitution says we must develop the common law in line with the Constitution. And if there's a common law principle that's inimical to the Constitution, we need to develop the common law, like the Constitutional Court has done in its early days in developing in the right direction. So my first answer is not enough of those cases are coming, but those that come, I've mentioned two. We are trapped in a conservative legal culture that has conscientized us to approach these things in a particular way. I think we need to get out of that. Then we'll see the development of the common law go more, probably in the constitutional direction. That's what I would say. We need to see a lot more of those cases. Not a lot of them are coming. And those that come, probably out of 10, maybe one goes the right way. The other 9 reinforce existing prescripts. I'm just saying this as a very general point.
Thank you. My second question is on the modernizations of our court. And I'm quite pleased about the project, how it's going, especially in the High Court. But one of the concerns that I do have, people tend to run to the High Court because they are disgruntled with the Magistrate Court and regional courts. Is there any way that we can modernize those courts, because that's where most of the cases are going? I take it that we have the single judiciary and we need to deal with the courts, the lower courts. Okay.
Thank you very much for that question, Commissioner. Yes, the vision of the CJ of a single judiciary is directly impacted in your question. When we talk of a single judiciary, we mean the magistracy also being part of one judiciary. Now, as we speak, the magistracy still falls under the authority of the minister, that is the executive, and hence our model suggests that they need to come to us, but there's a residual role. We need to grapple with it and understand its parameters. But the minister, in fact, the DG of Justice, the minister would have heard this. The magistrates are represented, especially in JADE, which looks at modernization in the courts. We've been able as JADE to actually prod the DG to actually enable magistrates, especially incoming new magistrates who are appointed with no tools, right? To enable them to be given the right tools. And when there are issues regarding the dysfunctional email system that's working there, Jade has been vociferous in saying to the DG, sort this out. So when we use cotton line case lines, we've mentioned to the executive, I remember mentioning this to one of the engagements I had with Minister Lamola, to say, we can't just leave the magistracy behind in modernizing our spaces. The magistracy needs to come along, right? And I understand there's a commitment to do so, right? But yes, you are correct. When we modernize the judiciary, we need to modernize the entire judiciary progressively. So I think that was your question, if I heard you, and that would be my answer. And we have a minister who's very, who acknowledges issues and has been very supportive in terms of the issues we've raised with her, and I thank her for that. And before I forget this, I want to thank you when your influence in the LPC for assisting Kausa to establish legal aid help desks in the courts. Most of these vulnerable litigants who are victims of the Section 46(9) or the foreclosure processes, they come to court because the sheriff has knocked on their doors. And when they leave court, at least they have a lawyer appointed through those desks to make sure that those lawyers try and assist them in terms of retaining their properties. So the LPC has been very helpful in providing the necessary funding for Kausa to run those help desks. Thank you very much.
Thank you, Chief Justice.
Commissioner Liganyan.
Chief Justice, thank you so much. Good afternoon, JP.
Good afternoon, Commissioner.
I'm going to ask you questions based on what you said here.
Yes.
Number one is that within the ensuing socio-economic context, which Commissioners Nguka Itobi and Marumo Agai have made reference to, you have spoken about the bottlenecks that continue to confine our people to poverty and inequality. And one of them is the injustice that is happening in communities that are endowed with mineral resources. And if you might have observed, or by now you know, the calamities that have happened in other parts of the world, like the Niger Delta, the Great Lakes, Sudan, and elsewhere. We might have not been visited by that scale as a country, but there is an injustice that is happening in those communities. And without asking you a question, just to get your comment or a transformation trajectory which you envisage, what is it that can be done to deal with that injustice?
Thank you very much for that question, Commissioner Lekanyane. You know, I sat in a case when I was in the SCA that dealt with minerals. I think that's still the law, if I'm not mistaken, to say you may own this land, but if minerals are found in this land, they don't belong to you. And that is based on a Roman Dutch law principle. I'm not sure whether we still have the space to support such thinking, because there was a reason why that law was developed in Roman Dutch law times. We have a constitution that seeks to transform our society. So I just need to be careful in answering these questions, because were I to be appointed, I may be ruling myself out of these cases, should they come. But I want to give you that example to say there's a legal culture. I'm going to continue to emphasize that is conservative. And I've worked in the SCA. You know, there was a contestation in those times, President Mlambo, that opposed the Constitutional Court being given general jurisdiction. There was a reason why that court had to be given that jurisdiction. Because you dealt with the situation of the two centers of power in the judiciary. And I don't know, it was correct for the CC in very resounding terms to say there are no two legal systems, common law and constitutional law. There's one legal system. And for that view to prevail, it was necessary to give that court general jurisdiction. So the view in that court at that time was the SCA should not be reduced to an ordinary regional appellate court, subservient to the Constitutional Court. That can be. And that's why we had these legislative enactments. So we will be doing ourselves a big favor in understanding this constitutional arrangement that we have and actually embedding our engagement with it as a judiciary, because I think that will take us somewhere in terms of making the Constitution a reality to those people who still think it's a myth. Let me stop there.
Thank you so much. My last question, you have sufficiently affirmed or reaffirmed your unqualified support to a female Chief Justice. And what I want to hear from you, because I think that the question that she asked was a condensed question. If you were to be appointed as the Deputy Chief Justice, it's what you have said here yourself, you are an activist judge in the crucible for transformation. To your knowledge, or from the rumors, or the whispers and murmurs in the corridors of the judiciary, what is the extent of patriarchal manifestation? And to the many women, the last we appointed here for the Western Cape as the head of the courts. In your position, how do you support not only the Chief Justice, but those many other women, so that a conducive environment is created for women to we interviewed them here, we were satisfied about their abilities. Now we want a conducive environment that can be created for them to thrive. But if there are entrenched patriarchal manifestations in the judiciary, it may become very difficult for them to succeed. And so that one day, you and I, we don't meet another person who says, you sold out. You have said it's a very harsh remark to come across. What is it that you can do, or you would be doing in that position to ensure that the transformation of women is indeed substantial, and whatever bottlenecks are there or impediments are eliminated for women to succeed? Thank you so much. That will be my last question.
Thank you for that question, Commissioner Lkhanyane. I'm not aware, well, let me talk for my division, of patriarchal tendencies in the court that are preventing women or that are blocking women from advancing. I want to believe we've done everything. We've got women to act in leadership positions. I'm not sure that it exists in Gauteng. And we've just had a diversity workshop. It didn't come out. If it exists in other courts, I'm not aware of it. I want to believe that the days of patriarchy belong to the past. The Constitution tells us we're all equal. And where these tendencies to crop up, I would be the first to attack and dismantle them. We don't have any God-given rights to lead as men. That's a thing of the past. Our Constitution has told us that. Chief Justice Maya has demonstrated where 3 other Chief Justices have not been able to make ground. She has made ground, even before the end of a year, in the executive agreeing to say, actually, you need to be independent. She's a woman. So I think it's a non-issue as far as I'm concerned. We don't live in a patriarchal society. And that would be my answer.
Okay. Commissioner Mangeni?
Thank you, CJ. Good afternoon, JP.
Good afternoon, Commissioner Mangena.
I've always thought to myself that you are one judge who is always looking for trouble, and today you have just confirmed it by criticizing your fellow judges, but positively so. And I'm encouraged by that bravery. And in line with what you have indicated today, that were you to be appointed the DCJ, you would, in your endeavor to assist the Chief Justice, ensure that there is a proper engagement with civil society. Because from where you stand, there may be a need for an awareness on the part of the civil society to understand how the Constitution functions. Now, but in the same breath, there is an issue about what you called threats to the rule of law, the unwarranted attacks on the judiciary. Don't you think that what you perceive as attacks on the judiciary, it's actually based on a poor understanding of how the judiciary ought to operate or is operating? And in that sense, what you have demonstrated today as criticism of some of the judgments, it's how society, civil society, chooses to express its views on the judgment that are often passed by the judges. So you've got to create a balance between what you see as an attack and what may actually be a constructive, maybe a constructive criticism, or the intention may be to be constructive, but it may come out to be seen as an attack.
Thank you very much, Commissioner Mangena. I take the point that there are instances when judgments are criticized, and maybe I should have said this very clearly. Constructive criticism is actually justified and is called for of what the judiciary is doing. Constructive criticism, you've said so yourself. But when a powerful person talks on national TV that the judiciary is corrupt, that's not constructive. And it's stated in general terms. That's not constructive. And that's the type of attacks I was talking about, because that's attacking the institution of the judiciary. To say the judiciary is corrupt, the judiciary is captured. I work in an environment where to say, if you want to attack me, tell me, is it that judgment? Have you exercised your right to appeal that judgment? But if it's based on no judgment, but just a comment, a remark, to say that JP there is has a vendetta against me as an individual, but you don't give facts as to what the vendetta is, that's unwarranted criticism. So I take a point, constructive criticism by all means. And that's why I've always encouraged our academic colleagues, to say there are those who comment on court judgments, that they should actually go ahead and actually expose gaps and faults in our reasoning and in our approach, because it helps us. We rely on academic writings in our judgments. So what comes from the academic field is constructive criticism, But to stand on a public platform and not single out any judgment, but simply mention a lot of negatives about judges and the judiciary, and the ordinary members of the public are listening, that's why I say it's a threat to the rule of law. So I think I'm answering your question. Constructive criticism, I agree with you.
No, you did. Indeed, there's no room for unwarranted attacks on the judges. Otherwise, indeed, it becomes a threat to the rule of law. The second and my last question, or a request for comment from you. On the 12th of October 2021, Daily Maverick published an article by yourself. Do you recall that article? The heading for that article was Judiciary's Mandate, Promotion of Equity to Counter Courtroom Inequality and Ongoing Social Injustice. You have no recollection?
Do I call that what?
You recall it?
Yes.
Okay.
I've not read it in recent times, but I think...
Well, you may not have read it in a long time, yeah. But in that article, you say something profound, that the courts must come down from their ivory towers to diffuse the situation of inequality and poverty in society by making justice accessible. But then you fell short of explaining how these judges who are at an ivory tower, who are required to come down, should do to create that space for access to justice. Do you care to comment and elaborate on it?
Thank you, Commissioner Mangena. I'm happy you asked that question. You see, as judges, we respond quickly to invitations by elitist platforms to go and talk to them. No, we're quick to respond to that, domestically or internationally. Our own people down there want to hear us. They want to see us. Minister Hadebe had a program of calling imbizos. I remember attending two of them when they were opening a court in Kagiso. I can't remember where the other one is, the second one. But he made sure that in these imbizos, he invites members of the public. He'll get the judge present to come. He'll get the head of the NPA to come, head of Legal Aid South Africa to come, because he's there as a member of the executive. And he'll invite people to actually tell us to our face what their frustrations are on the ground in the courts, in the court system. That's profound. You know, in one of the imbizos, I got the ministry to take down the names of all those people who were mentioning their frustrations at accessing the court level, where they just find judgments against them, but when they want to go. And it was so beneficial to me because I was able to engage with the heads of those courts to say, this is the case number. Can you tell me what happened? That's where I came across the frustrations on the maintenance front. You know, to say the women get an unfriendly, unwelcoming, actually repressive system when they seek to get maintenance for their children, right? So I'm saying we need to respond to those calls as well. We need to hear these people talk to us, tell us. And then when we go back, we need to make sure that we take action to make sure that we unshackle those bottlenecks and ensure that people actually get meaningful access to justice. So that's my answer to you. I meant that. Get out of there, ivory tower. Go down to where the people are. Let them talk to you. Let them see you. Let them engage with you.
Thank you, JP Mlambo. Thank you, CJ.
Commissioner Motlo?
Thank you, CJ. Good afternoon, JP Mlambo.
Good morning, Commissioner Mutlo.
Thank you. My question emanates from your presentation on access to courts. And I picked your remark on how can they access courts when they don't have funds. And this, to me, says there is an acknowledgement that our justice system, in order for one to access courts, you need funds, and thus it's expensive to access justice. And this talks to Section 34 of our Constitution, which in my view is sacrosanct, and is also a cornerstone, which in a way creates that interface with access to justice. If people cannot access courts ordinarily and automatically, that will be an impediment and a barrier in accessing justice. And one looks at the legislative framework aimed at ensuring meaningful access to courts, and one cannot resist the temptation of looking into the Small Claims Court Act, for instance, which, by the way, is an old act of 1984, and which, if one looks at it, and the object of having such act was to bring about access to justice, access to courts. But to what extent is this legislative mechanism there to ensure impactful and meaningful access to courts? Because you have a situation where, one, the presiding officers in such courts are drawn from the ranks of from legal practitioners, and there is little vetting of such legal practitioners, particularly checking and ensuring that their knowledge of the law is at a level that is acceptable. But two, you have a situation where such court, if litigants would want to challenge the findings of such courts, they are unable to do so unless they are to proceed by way of a review, decisions emanating from such courts are not appealable. And that on its own creates a barrier, because you have a situation where a litigant who's disgruntled and who would want to take the decision from that court on is barred from taking it anywhere else other than to go to the High Court. And this talks to the very same remark that you mentioned, the remark about the lack of funds. Because if they are only channeled to approach the High Court for review, that on its own is an impediment. But you also have a situation of circuit courts, and this circuit court's jurisdiction only extend to criminal matters, and they do not, they fall short of bringing about meaningful and impactful access to courts. Now, against this backdrop, I would like to get your view in your role as the Deputy Chief Justice. What mechanics would you put in place to ensure that we deal with these blockages in a manner that will benefit our people, that will benefit the poorest of the poor, and ensure impactful access to courts? The second leg of it would be, what would be your view with regards to proper implementation of traditional courts in ensuring that it closes that lacuna and ensure that the people have access to speedier resolution of their matters through such establishments, and also with regards to the use of paralegals. I know that you are the chairperson of CAUSA, and to the extent that there are community advice offices out there, but the reality is that the use of paralegals is not necessarily formalized, it's not legislated. What role could they play to ensure that they bring about impactful access to courts? Thank you.
Thank you, Commissioner Mlambo. Starting with the last question. Paralegals play a critical role in access to justice. My view is they provide primary access to justice. That's the first point of contact of any ordinary person with the justice system, with a paralegal down there. So that's primary. Now, it's not formalized because the legal profession didn't want it in the Legal Practice Act. I'm sure you know it. The provision about paralegals playing a role in the justice system was there until the final stages of the LPA Act. As chairperson of CAUSA, we have initiated discussions with the LPC to bring it back, because the legal profession regarded paralegals as being in competition with them. They are not. Paralegals don't charge any fees, and they deal with matters that lawyers can't charge fees on. So that's the question I want to answer, that this needs to be funded. And it's good that the Treasury now funds paralegal operations through that project called Pledge, right? Because I used to be very sad. You find committed paralegals going from month to month working, assisting members of the public and not getting paid because they don't have funding. Because funding is a big reality in that sector. So that's the one thing. You mentioned the issue of the small claims court. Not everything about the small claims court is bad. To start with, in fact, a lot more can still be done in reforming the small claims court arrangement, and you've raised those issues. But I remember when I was a fellow at the LRC, we brought a lot of relief to ordinary litigants in the small claims courts. I mean, some of you remember there was a car dealer called Franz Esser who boasted one time of selling one car 60 times. So we assisted vulnerable litigants access the small claims court to get relief at no fee. So I'm saying it has played its role. It needs to be reformed to deal probably with the criticisms you've mentioned. And I'm happy the Minister of Justice is here because it still falls under her. Right. So other than that, mine, if I were to get the honor of being appointed as Deputy Chief Justice, is to get the Chief Justice's buy-in in getting members, other members who are involved in the access to justice food chain to actually be in tune with the realities on the ground, the needs, and how the situation can be enabled. I think that's the answer I can give to your question. Thank you.
Thank you, JP Mlambo. The last question from
I
me.
wonder if you have not exhausted your quota with your multi-pronged question, Commissioner Mutlo. We still have a few other commissioners to put questions, and we've run out of time.
Okay.
Thank you.
CJ.
Commissioner Pillay?
Thank you, Chief Justice. Good afternoon, JP.
Good afternoon, Commissioner Pillay.
JP, I was a bit concerned by your response to a question from Commissioner Lekanyani, where you said that you are not aware of patriarchal tendencies in your court. But I also remembered that in your vision, when you presented your vision this morning, one of the issues you touched on is the importance of a sexual harassment policy in order to properly transform the court spaces. But you accept, JP, that patriarchal tendencies manifest in a number of ways, including harassment of women.
Perhaps you are correct in reminding me of that, but the remark I can make, and I think it's a profound remark, but it's necessary. When I said I'm not aware, I suppose what I meant was nothing has come to me that evidences this kind of conduct in how our female colleagues have been treated. And perhaps I was too eager to give the wrong answer. I take your point on that. But let me say this about sexual harassment. It's a problem. It's a problem. And Chief Justice, I don't know if, I know I read the current draft of the sexual harassment policy that's at the heads of courts that's being revised. I'm not sure if there's a provision there. I think there may be, to say we need meaningful sensitization programs for members of the judiciary regarding this issue.
Just to tie that answer, JP, up with what you said earlier,
Yes.
that you're not aware of these kind of incidents taking place in your court. One of the difficulties, even if a sexual harassment policy is in place,
Yeah.
one of the difficulties you'll encounter is that women are scared to come forward. And I wanted your view on two specific aspects, which I think are defining features of the judiciary. The first is that the judiciary is inherently hierarchical in nature, which makes it difficult for women on the lower rungs of whatever the space is to come forward and raise complaints of sexual harassment. That's the first thing. And the second thing is the existing complaints process. Even though it describes, for example, the tribunal process as an inquisitorial process, the design of the process is such that it mimics an adversarial process, so that if a woman is to come forward, should be required to testify, and then would be subject to sometimes grueling cross-examination. Two features which would certainly inhibit women from coming forward. Now, I just want to get a sense of your thinking on how that can be catered for in this proposed sexual harassment policy?
Thanks, Commissioner Blake, for that question. You know, in a different context, during the diversity program 2 weeks ago, a view came from the judges that we need to create safe spaces where people can express themselves where they've been ill-treated. But those are in a different context, right? And I think any policy must have that safe space for persons who have been the victims of conduct that they view as invasive, unwanted, and of a sexual nature. We need to have those safe spaces where they are able to report and for them to actually express how they want this whole matter to be dealt with. We had one instance where a woman, judge's secretary, complained to the office manager, who's a woman, to say, look, this acting judge is sexually harassing me. These are the messages he's sending me after hours. The office manager promptly, I think I was away, spoke to the DJP. The DJP promptly alerted me. I said, this moment, ask the office manager to engage with the judge's secretary, right? To understand that we want to support her and we want her permission for this matter to go forward. That judge's secretary said, no, I need to be removed from working with this person, and that's all I want. I don't want anything to go forward. But we went a step further. We revoked the acting appointment of that person on the day, and we reported that issue to the bar where that person came from. So I think my answer is the creation of safe spaces. But this should be an issue that's discussed, and I want to subject myself to the leadership of the Chief Justice. She has taken ownership of this process, and I think we all will learn. I don't have the answers. I don't have all the answers, but I recognize that there is a problem. That's why I'm mentioning this case, you know, to say we need to find the answers and ensure that we create a welcoming environment. We have safe spaces where our women colleagues act properly. Are treated properly, that is.
And so you haven't thought, JP, how we could accommodate for these concerns that I've raised with you, how we can accommodate for that in the draft policy?
Well, I think, as I say, one example is a safe space, but the current process is the draft is being taken through working groups. It will still come back to us. We'll look at it and we'll check what may be deficient from it, and then we'll suggest necessary amendments to it to ensure that we live by what we say when we say it needs to be a safe and a welcoming environment that is free of unwarranted conduct.
Thank you, JP. Thank you, Chief Justice.
Thank you, Commissioner Pillay. And just on the question of the sexual harassment policy, I want to say that we have enough that warrants a conclusion that there is great need for that policy in the judiciary. And to address the concern you raise about sensitization of judicial officers, the draft that is in circulation and will be issued very soon does make the training and sensitization of judicial officers and the creation of a gender desk for the judiciary urgent priorities. So I hope that allays your concerns, Commissioner Pillay. Commissioner Hassan.
Thank you very much, Chief Justice. JP Mlambo, good to see you. I know it's not a fun thing to be on the other side of the table, but we are where we are. CJ, I have the first question, and it's actually related to accountability, JP. One of the often unspoken challenges in the judiciary is about holding fellow judges accountable when ethical or professional standards have been breached, particularly when it involves peers within one's own division. And you've been amongst the few judicial leaders who have actually reported colleagues to the Judicial Conduct Committee, even when it may have been uncomfortable or unpopular to do so. Can you speak to your approach to judicial accountability and what it takes to uphold the integrity of the bench when the duty to act is neither easy or convenient? And this is especially given that you are seeking appointment to the leadership of the apex court of the country. Thank you.
Thank you very much for that question, Commissioner Hassan. My approach to judicial accountability is to recognize that our existential role as judges is to hear matters and hand down judgments. That's a given. And in the division that I lead, I always tell colleagues that if you find yourself you are in trouble, you need time to write your judgments. You must tell me so that I can see what I can do without overloading other judges, but so that I can see how I can give you that time to write those judgments. And I don't quickly report colleagues. I give them time, those who come to me, and then I track them. Have you done it? Why have you not done it? Right? And then there are those who simply ignore me. You realize 2 years down the line, there are 5 judgments that have not been handed down. And you consult the colleagues, one is say, well, look, I lost my laptop or my laptop crashed or one or other reason. Say, well, can you give me a timeline when these judgments are going to come out? I think as a judiciary, we need to be properly transparent in accounting about the failings in our ranks in terms of fulfilling our judicial role. I think that's one thing, because when we properly account, it tells South African citizenry that, well, they are aware of it and hopefully they're going to be addressing that issue. So as you say, if one were to be appointed as Deputy Chief Justice, I think the Chief Justice issues a quarterly report about, especially on these aspects of reserve judgments and other related issues. I think in the heads of courts formations, I would like to think the Chief Justice would engage. And I think it's one of those issues that we can discuss in the retreat that I suggested, because there are courts that don't have that problem. There are courts that don't have a reserve judgment problem. And there are courts that are always leading, right? And my court, Pretoria in particular, is up there. And look, it's not that I'm not doing anything. You can do so much. If everything you've done fails, you report. But then there's the other issue that the reports that you file, how long do they take to be processed? And I know the CJ has introduced mechanisms to increase the number of JSC conduct members to ensure that there's speedier turnaround times in terms of these complaints. So accountability, yes, we need to account for our failings. And we need to assure South African citizens how we will make sure that those failings don't recur, especially on that front. Let me confine my answer to that.
CJ, just as a way of follow-up on the accountability question, before I get to my second thematic point. JP, I'm sure you're aware that the Commission's received concerns regarding the delay of a particular matter, and I raise it now because you've mentioned timelines taking a long time, etc., etc. So the delay of over 10 months in finalizing an application for leave to appeal in the Lembore matter. And as we know, it's significantly longer than set out in the judicial norms and standards. And while you've indicated that there's been procedural communications that may not have reached your chambers, given what you've just said to us, how do you reflect on that delay? And what measures do you believe senior judges or those in leadership should take to ensure timeous justice is delivered? Thank you.
Thank you for that question. Leave to appeal applications, as a rule, must be treated as urgent court applications. As I say in my response, I wasn't aware of that application for leave to appeal until I saw the complaint or the objection to my candidature here. I take full accountability that it has not been processed, because it had not been processed until we received it, but we've now processed it, right? We're going to be dealing with it expeditiously because it's long overdue. But what I say there in that response is the chambers of the judge against whom leave is sought needs to be recognized, or communication needs to be sent to say there's a leave to appeal application, we've had no response, what's happening? Because as a given, that's the process in Gauteng. You file a leave to appeal application, and usually the appeal section would alert you to say, hey, JP or Judge Nkosi, there's a leave to appeal against this judgment. Then you are able to set aside a lot of other things to deal with that leave to appeal, right? And if a period of time goes by, say 2 months, which by itself is too long, goes by, where the person who seeks leave has not heard anything, they know there are channels of writing. My email address is available publicly. The secretary who serves in my office, his email address is available publicly. No such communication went there. I'm not blaming them, but I'm just saying, if they were really serious about this application being heard expeditiously, communication would have been sent to my office to say, why are you not dealing with this matter? So I take blame. It's not happened, but we're addressing it. The judgment should be out in the next month or so.
No, thank you, CJ. I appreciate the maturity in the response. My second question, JP. In your presentation to the JSC, you raised some grave concerns about the growing trend of powerful individuals who are often facing legal scrutiny themselves, launching unsubstantiated and, let's be frank, politically motivated attacks on the judiciary and often on individual judges. And I think it's important for us to also say this because they're not just criticisms, they amount to intimidation and an attempt to delegitimize the courts and the judiciary. So in your view, JP, how should the judiciary respond to this kind of assault on its independence and authority? And what role should senior judicial leaders like yourself play in defending the institution, not only legally, but also publicly, morally, and the attempt to recreate and reinvest, I would say, trust in the institution as well? Thank you.
Thank you very much for that question, Commissioner Hassan. I think I've given one part of that answer to the minister when she asked me the question earlier, that we can raise it in the engagements with members of the executive. But we can also use the opportunities we get in terms of addressing public platforms in dealing with these particular concerns as members of the judiciary, just to assure South African society that we are aware of this and there's no truth in them and saying exactly what the issue is. But in all those engagements, we always reinforce that if anyone has an issue to raise against the judge where they think a judge has misconducted himself or herself, that should be sent to the JSC for the JSC to process.
Thank you, CJ.
Oh, sorry, my mic is off. Commissioner Mlambo.
Thank you very much, CJ, and good afternoon, JP.
Good afternoon, Commissioner Mlambo.
I just want to understand, what do you mean by South Africans are gullible?
What I mean is they tend to believe anything and everything they hear.
But what is
not
that?
All of them. Not all of them. Yes.
Oh, because I just heard a sweeping statement that South Africans are gullible.
No, not all of them. Sorry.
Okay. Now, there's a crisis there of 170,000 maintenance applications which are not being resolved. And not so long ago, I think the Department of Justice was launching one of the programs to hand over the defaulters to credit bureaus so that they can be blacklisted. But you can't blacklist people who are not there. They are stuck there by the maintenance courts. And in this case, the latest was 170,000. What can be done to resolve that issue? Because it means there are more than 170,000 children, African children who are starving, who are going through hunger. And the court is not intervening speedily to ensure that it alleviates that hunger and poverty amongst African children. Thanks.
Thank you, Commissioner Malema. That's a very worrying situation. And you are conservative by saying 170,000 children. It could be double. Now, look, the executive, the maintenance calls fall under the executive branch of government. I think if they consult with us, we may find ways of saying, how do you, if it's capacity related in terms of processing these claims, how do you increase capacity over a short period and process these claims as quickly as possible? You're correct that you can't just hand people over to the credit bureau. Some of them may not be aware, right? So that's one aspect that can be done. Increase the capacity of the people who process these claims. But Commissioner Malema, you and me know this is an age-old problem. And probably it's an incident of the patriarchal society issue that Commissioner Pillay mentioned, because mostly it's women that come and ask for maintenance. They are treated in this way. It's something that needs to be addressed frontally, right? As I say, when I tried, I heard on 702 driving to work that there was a big problem in the Randburg Maintenance Court. So when I phoned the chief magistrate to say, hey, there is this issue, and then the response I received, that was a few years ago, probably 4 or 5 years ago. The response I got from the chief magistrate was, look, maintenance officers don't fall under the courts. They don't fall under the judiciary. I said, but that's strange. They are located in the court. You as the head of the court should have oversight over them. I said, no, I don't, right? I think whether it's the family advocate or who has jurisdiction over them. And I said, no. This must be addressed, right? But I remember talking to the DG to say, look, we need to do something about this, because if it's publicized on radio, we've heard it. Having heard it, what have we done about it, right? It's away from me. But I suppose as DCJ, Commissioner Malema, nothing prevents me from saying to the Chief Justice, this affects a large component of South African society. We need to engage the executive in coming with an effective way of ensuring that there is a credible and effective system of dealing with these things and making sure there are no backlogs that are created. That's all I can say, Commissioner Malema. I acknowledge the problem.
Thank you, Commissioner Malema. Commissioner Baloyi.
Thank you, CJ. Good afternoon, JP.
Good afternoon, Commissioner Baloyi.
Yes. The first question is about the compulsory mediation, and I'm not asking you to speak to the matter that is presently before court pending, but I want to talk about the general concept itself. If you were to be appointed as DCJ, I would assume, and assuming that the court clears your directive and accepts that it is permissible, that the court can order that there should be mediation. I'm assuming that. One would assume or expect that if you appointed DCJ, this is a project that you would try to get buy-in for, to be distributed or to be spread across the country from the CJ and from the other heads of courts. Now, perhaps if you would speak to why this idea, this innovation, but more importantly, how would you ensure that this does not become another administrative step, another annoying administrative step in the process for matters to be heard? And I ask this question because of experience of mediation under the LRA, where often parties rock up without any meaningful intention for matters to be resolved at mediation. What do you say would have to happen for this to be a successful project that serves its intended purpose? And its intended purpose being what?
Thank you, Commissioner Baloyi. I think this step needs to be viewed as a Gauteng-only initiation that seeks to address a particular problem in Gauteng. And when I say that, I and the leadership, it's an inclusive project, by the way, it's not only mine. The 2 DJPs and some judges in the division are part of the team that's behind this project. Our view was, let's arrest this runaway train of a wait of 5, 6, 7 years for a trial date. Let's introduce something that will not deprive people of their access to court, right? But of saying, because of what happens when you eventually land in court, we think you can get justice quicker if you go that route. That's what it is, just a divisional measure, initiative to address the current situation. The long-term solution lies in what that subcommittee of the Law Reform Commission has published, a mediation bill, which targets part of this area that I have. So in terms of long-term longevity, of the directive, I don't think it will last a long time, right? But it will apply for as long as we want to assist litigants come to court quicker for their matters. That's the objective behind the directive, to say you are in 2025, you get a date in 2031. That's inimical to access to justice in the constitutional sense. So what do you do as a head of court? You find another way to ensure that those matters that genuinely require a judicial engagement are given earlier dates. When you've removed the chaff that's simply clogging the roll, simply because you're waiting for the trial date to come and then you'll meaningfully engage each other then. The directive simply says engage each other earlier and resolve your disputes and your differences earlier. And that matter will not come back to the court. Other matters that are deserving of judicial attention will then go on. So I think that answers both your questions in terms of longevity. The bill that's been published, I don't know when it will happen, but it's there. But the directive is not of a permanent nature. It is meant to arrest the situation that we have, right? And perhaps if we get more judicial posts, we'll find a way of ensuring that we ease its effect.
I guess the main part of my question really, JP, was how do you make this an effectual step in the litigation process, avoiding that parties go to mediation because they are compelled to go to mediation, but they just present without any meaningful intention to get matters resolved at mediation and thus turn this innovation into just another step that must be ticked. Have you thought about how you make this to be an effective step?
Well, thanks for the follow-up question, Commissioner Malloy. That's why we've said the report we get of the engagement with the process should tell us that there was meaningful engagement between the two parties. And that is, if there was no meaningful engagement, then we've created a shortened step as to if this matter was on the trial roll in January 2026, but you've gone through the hoops, you are in August, and you've had no meaningful engagement, no meaningful response to your request, we've provided a route for you to go to the TIC court or the SIU court where you can get the relief you would get in 7 years' time. So we're making it effectual in that sense.
Thank you. CJ, the second is more the work of the committee, the objections. I don't know if this is the point to put it.
Yeah.
Commissioner Hassan had already touched on one aspect of it.
This would be the right time, but before you get to it, Commissioner Balo, you may just follow up on your first question. JP Mlambo, in your response, you say this directive is only, is divisional.
Yeah, that is correct.
It's meant only for the purposes of your division. But as you and I know, the challenge is not confined to Gauteng. There are a few other divisions that are afflicted by the same problem. The position of DCJ is a national one. You would not just be minding one division. If you are appointed, would you push for the implementation of this directive, assuming that it passes it passes through the hopes of the litigation and passes constitutional muster, because one suspects it will go to the Constitutional Court finally, where it started, by the way. Would you push for its implementation across the board?
Well, CJ, I think it's a catch-22 situation.
In the short term?
In the short term, probably, because I know I've seen one court order from Limpopo directing people to mediation. I've seen another one, I think two, from Mpumalanga, directing parties to mediation. So you're correct, CJ. It's a national problem. It's more acutely felt, however, in Gauteng, which is what drove us in the division to issue it. So in the short term, probably, yes, we would push for it to be of national effect. But I think the chair of the Law Reform Commission has written to the heads of courts about our view to the mediation bill, right? So it has our support. I would rather want to see a situation where that mediation bill process is expedited, so that this piecemeal treatment of this national problem is arrested by an act of general application by way of the Mediation Act when it comes. But yes, correctly, were I to be appointed, I would request the Chief Justice to get the heads of courts to wrap their heads around and see how we can extend the ambit of a directive of this nature, or even improve it to apply to other divisions. I would do that, yes.
Yeah. Well, Minister Kupai and a few parliamentarians are here regarding the fate of the bill. So one hopes they're listening and, understand the problem which the courts face in this regard. You may proceed.
CJ, can I please follow up before?
Yes, Prof.
Yes. Thank you very much, CJ. JP, I had a chance of looking at the discussion paper on alternative dispute resolution, South African Mediation Act for South Africa, that tries to provide an overview of how the South African Law Commission actually is thinking about where the role of mediation in South Africa. One thing that I do not see coming out, it is while the kind of like advocate for mediation and try to explain the importance of mediation as an alternative dispute resolution, the issue of training of mediators doesn't come out very strongly. And I think one can tie that also with the proposal of how we ought to deal with mediation within the Gauteng Division. That, yes, this is a positive step, but it doesn't seem like there is much emphasis on the training of mediators. Because when you have spaces like family law, there is training going on there, labor law, there is training going on there. But when we are dealing with other areas, which might be a little bit more complex, most of which generally are dealt with arbitrations and all those kind of things, how should we approach this innovation in line with the necessary training that is needed to ensure that the system operates? And I think that is the discussion that we are not having.
Commissioner Marumo Achai, thank you very much for the question. I want to admit we didn't focus on training when we issued this mediation, because if you see what we are reliant on in terms of the mediation services are the mediation bodies that are there. But this issue of training has now come back forcefully. But you see, we don't have the resources as the judiciary to train mediators, right? And it's something that we need to think about how it can be done, because we've received a number of proposals about how ordinary members of the bar or the legal profession can be trained and actually assist in doing this work. So upfront, as I say, we didn't think of it because with that we'll utilize the existing mediation bodies, right? And that's why there's a schedule that talks about them. And we have to amend and make sure clarify what role these mediation bodies are. So I take the point. We didn't think about training, but yes, mediation training is important if one wants to see it successful. I agree with you.
Thank you, JP. Thank you, CJ.
Colleagues, we were supposed to break for lunch about an hour ago, and the next candidate is waiting. But we still have 3 commissioners to go through, and I was wondering if you would mind terribly if we just finish with this, just plow through and finish with this candidate, and then take lunch, an abbreviated lunch at that. Okay, thank you. That takes us to Commissioner Nkonyana.
Yeah, thank you, CJ. Good afternoon to you and to fellow commissioners. Good afternoon, JP Mlambo.
Good afternoon, Commissioner.
Yes, thank you very much for availing yourself and for actually setting out your vision if you are appointed in this very, very important position as it is DCJ. I have read through, I've listened to you, but there's one thing that I didn't hear, which necessitated this question. There is a cry in South Africa from traditional communities and activists in the field as regards the issue of equality between Roman Dutch legal system as well as African/indigenous legal system, which is set out in the Constitution. They are equal, of course, subject to the Constitution, as you know. Now, I didn't hear you. I didn't read anything in that regard. But my question is, what is your vision, therefore, in addressing this legitimate concern?
Thank you for that question, Commissioner Nkonyane. I think the Constitution is clear that African traditional law is not subservient to any other law other than the Constitution, of course, which is the supreme law. And I want to believe that the judgment that I wrote in resolving the kingship in the Bapedi situation actually confirms the answer I'm giving. That in the 1980s, a judgment was written that was not in line with African traditional custom, but that sought to preserve that system. And the argument before me was res judicata. That judgment has resolved this issue. The commission had no basis to look into this. If you look at the two, there was more the leaning towards applying Roman Dutch law in that judgment, the 1980s judgment. The Constitution says we're forward-looking, but we can look back and correct what happened in the past for us to move forward. The Commission was resolving this dispute in line with African traditional system, and that's putting the African traditional legal system in its right place in terms of the Constitution. And that's what I did. So I may not have mentioned it, but the Constitution is very clear. There's no subsidiary legal system. Only the Constitution is supreme. And if there's an opportunity for us to advance a traditional legal rule, we should, as long as it complies with constitutional prescripts.
Thank you, JP. The second one, the last one from me, you said something that resonated with me, the localization of legal services, where the people are. The Office of Chief Justice, since the reign of the then Chief Justice Mogoeng, did highlight the importance of traditional courts as part of the judicial culture in South Africa. What will be your vision in that regard?
I've interacted a lot with colleagues in Botswana who have a very functioning African traditional court system. I'm sure you are aware of that. And asked how we could emulate them in this country. They've given me their views, but I think we've been remiss in this country in allowing this bill to remain in the back burner for this long. I mean, all the red lights were pointed out about what needs to be addressed for such a court system to work, right? And I think we just have to be brave and ensure, because I think patriarchy reigned the most as one of the reasons why this bill shouldn't be allowed, shouldn't be passed, because of the ongoing patriarchal nature of things in the traditional sense. But training, you know, the traditional justice system is based on mediation. It's not adversarial. And if there's proper training of people who preside in those courts in the tribal areas, I don't see any reason why. And if we have a transparent system in terms of which decisions coming from those courts will be treated if anyone is unhappy with that can be addressed. So I think we need to go back to the drawing board, you know. The same answer I gave for the small claims court, I would give the same answer here to say, look, the Chief Justice is the head of the judiciary. The justice system has a big role to play in how the judiciary functions. And as DCJ, this is a conversation we could have. Say, CJ, small claims court, maintenance law court, municipal courts, traditional court system. What interventions can come? What can we suggest in ensuring that ordinary South Africans get the advantage of these processes? I think that would be my answer, Commissioner.
Thank you, CJ.
Okay. Commissioner Trollip?
Thank you, Chief Justice, and thank you, Judge President, for your comprehensive and specific representation about what you would bring to this position. Your candidacy was accompanied by a number of complaints, which led me to think of the adage that the tallest trees collect the most wind.
I'm sorry, I'm struggling to hear you, Commissioner Chole. Would you bring your mic closer or at least speak into it?
Yeah, thank you. Sorry. I said to the Judge President that his candidacy was accompanied by a number of complaints, which led me to think of the adage that the tallest trees collect the most wind. And the matter of abuse of positions of power or authority leading to overbearing behavior and sexual harassment is rightly a matter that's in the forefront of public debate and is even being dealt with in our courts where senior jurists are implicated or are involved. You yourself were previously ambushed by such allegations that were found to have been unsubstantiated and then subsequently expunged from the record of your previous appearance here. But you said in your response to one of the complainants, Wise Africa, that you had not attended gender-specific training per se, but that you had attended diversity training in 2019 and that there was more training scheduled for the 17th and 19th of this month, of June. Did you attend that training?
The diversity
Training.
workshop, yes.
Yes.
I arranged it. I was there.
Thank you very much.
Yes.
And then, JP, notwithstanding the testimonies of senior judicial leaders here present about your affirmation and commitment to gender empowerment, could you contextualize and elucidate us a bit about your response to Wise Africa about a case where 2 judges were involved in sexual harassment or allegations of sexual harassment, where you included the support or advice of a retired judge? Don't have to go into the merits of the case, but just to give us an idea of how you dealt with it.
Thanks for that question, Commissioner Trollip. 2 judges in the Pretoria Division approached me on separate occasions, telling me that there was one colleague who was harassing them sexually. And you know, I don't know if I mentioned it, but when you lead judges, you lead intellectual beings. You are able to sit and reason and talk to them. And I asked, how long has this been going on? And it appeared that it was not of long duration. And I said, so should we initiate the complaints mechanism? They said no, they don't think they want to go that far, but they want, because they feel they've been affected, right? They need an engagement of sorts. And I asked them, I will speak to the judge concerned and tell him to stop with your permission. And 2, when you say they said they needed to speak to someone senior where they can offload what they've been subjected to and probably get counseling of sorts, right? And that informed my decision to source the services of a retired Constitutional Court judge to talk to them. And this was with their consent and agreement. And they had that discussion, and that was the end of the matter.
CJ, could I just
You
have
want a third question now?
What's that, ma'am?
You've asked 2 questions.
Can I just have a follow-up, brief follow-up?
All right, make it brief.
JP, they say in this regard, sexual harassment, that it's unlikely that a leopard will change its spots without remedial attention. What are your thoughts about that?
I'm sure there could be truth in that, but I want to believe that when disciplinary action is taken against an individual for having done something that individual should not have done, that would say to that particular individual, this is not a go, this is no-go area, don't do it again. I think I can leave it at that, yeah.
Just a quick follow-up. JP, when you speak to people who come to you that who are being harassed here by this and that, and you ask the question, how has it been going? For how long has it been going? They tell you, what do you want me to do? And then they say, no, we just wanted to ventilate this matter with someone senior, and you leave it at that. Had you proceeded to confront that person or even subject that person to some form of a disciplinary process against the wishes of those complainants, was that not going to be harassment on its own?
Commissioner Malema, thanks for that question. They had specifically no, they don't want to go there, but they gave him permission to confront the person, and I confronted the person, and I told him to stop. Yes.
Commissioner Kotze?
Thank you, Chief Justice, and good afternoon, JP.
Good afternoon.
You remarked that whilst the workload of judges has increased, judicial capacity has not. Having regard to the financial constraints faced by the judiciary, what practical steps would you take as the Deputy Chief Justice to address the strain on the judicial capacity?
Thank you very much, Commissioner Gottsel, for that question. Well, there's no two ways about it. The judicial capacity has to be increased. But that's not the only solution. We need to take advantage of other tools that we can use to assist us. I know when I mention artificial intelligence, I raise eyebrows. But in 2 weeks' time, or next week, during the SAGE conference, we'll have a judge from Brazil talking to us about how that jurisdiction has enabled rules-based AI in helping them, not decide their cases, but as tools from case flow management, research assistance, and how that has made them more efficient. So I think we need to take advantage of more of what's in the environment that we can use around us. But the increase of judicial posts is a must. The increase of the support levels, the staff support levels, is a must, as well as the infrastructure within which we work. That's a must. So those are discussions that the CJ has already started, and I'm going to be supporting her fully in that regard.
Thank you, CJ.
Commissioner Baloyi, do you want to follow up on your objections?
Yes, thank you, CJ. But perhaps, CJ, before I do that, I've just confirmed with Commissioner Ngaitobi, the chairperson of my committee, and we think in the light of an exchange, part of the exchange with Commissioner Trollip, it's necessary for us, for completeness of public record, that we say something about this aspect. You commissioners, we did report earlier the objections that we received, and one of them was from Women Inspired Solutions for Empowerment, WISE. Commissioner Trollip refers to the previous interview of JP Mlambo for the position of Chief Justice and the ruling of then President Petse, that part of the interview should be expunged from the record. Now, the WISE has this time around sought to have filed what they refer to as an objection relating to that same issue without any facts. What they've said is this was raised previously, it must still be discussed with JP Mlambo. And the committee, as we reported this morning to the private meeting of the JSC, was that we have considered that objection, and we took into account that this was the subject of your last appearance when you appeared for the candidature of Chief Justice. And there was a ruling by the chairperson, then Deputy President, I apologize, Petse, that part of the record should be expunged from the record. That decision stands, and the committee decided that we are bound, the JSC is bound by that decision of Deputy Judge President Petse, and taking into account that what WISE has raised this time is exactly the same thing. It doesn't have any facts. It simply refers back and says, well, that should be rehashed again. We decided it wouldn't be put to you, and that's what we we reported back to the JSC this morning. So as a matter of public record, there is no, as far as we're concerned, there is no objection that needs to be put to you, and that needs to be responded to on this aspect. Coming to the objection that you should be given the opportunity to respond to, this arises from the Lambore matter. JP, you were given the objection from the counsel and attorney who appeared before you. It was a matter before you and Judges Twala and Judge Collis. And the objection from these legal representatives, there's two parts of it. Commissioner Hassan refers to the fact one as a concern. It's in fact one of the objections or grounds for objecting, the delay in delivering a decision or a judgment on the application for leave to appeal. You've dealt with that, and we don't expect you to speak to that again. The second part of it, which you are aware of and you have responded to, is the complaint, or the complaint, in fact, that you made an order, your full court made an order that the legal representatives in that matter of the applicants should be personally liable for costs, but you also ordered that their conduct must be brought to the attention of the Legal Practice Council. The complaint and ground for objection is that your court made those orders without affording them the opportunity to make submissions, both on the risk or on why they shouldn't be marked with personal cost orders, and to what they refer to as the adverse comment about them, that their conduct deserves a referral to the LPC to look into. You have responded to that, but perhaps this is the opportunity as well to deal with it publicly. And we put this to you quite aware that these same issues are the subject of a complaint before the JCC. Thank you.
Thank you very much for that question, Commissioner Baloyi. It is correct that I've responded. I think the remaining part of that complaint is that we handed down the cost judgment without a hearing. That is not correct. There was a hearing, the main hearing, and when we reserved our judgment on the main matter, as well as that part, we singled it out specifically. We said, we are concerned that you may have engaged in professional misconduct, or there may have been some malfeasance in how you went about dealing with this matter. We request you to file affidavits, you and your clients, to file affidavits and tell us what your view is of our concerns, right? They didn't respond to that. What they did was to apply for leave to appeal the main judgment, where we had not decided that part. So it's like, instead of giving a judgment to say the application is dismissed and costs are the following, we reserved the issue of costs because we said, talk to us, tell us why we shouldn't go there. They didn't. And then when they didn't, they applied for leave to appeal. We didn't issue our judgment. We dealt with the leave to appeal on the main judgment and dismissed it. Only after we dismissed it did we then deliver the judgment. We also waited some time, actually, before we delivered the cost judgment. We waited for some time and they didn't come back to us. What they did was to file a petition with the Supreme Court of Appeal. In my view, the way I understand the law, a petition does not suspend the operations in the previous court. That's my view of the law. They seem to think because they filed that petition, we should have held back and waited for the petition to be dealt with, and once it's been dealt with, to see what happens if they go to the Concord, to also wait for them and see what happens there. That's not my reading of the law, and that's why I responded in the manner I did, that they were given an opportunity, right? And once they didn't exercise the opportunity given them to file affidavits explaining themselves, we were at liberty to issue the cost judgment, which they've now applied for leave to appeal and which is the subject of the other complaint. I think that's the response I gave. That's the response I give now.
The second part to it, so there's the cost issue, but the
Yes.
second part of that complaint is that you made an adverse comment about their conduct.
Yes.
To the extent that you say it should be referred to the LPC.
Yes.
And they were not given the opportunity to deal with that part.
Well, I suppose what it boils down to is they're saying, whilst they were not given an opportunity to deal with the cost judgment, they should also have been given an opportunity why we should refer this matter to the LPC. I looked at the code of conduct, the rule they refer to. It doesn't support that stance. Not at all. And I want to believe that the opportunity we gave them to say something was enough. And in any event, whatever adverse comments we've made are not binding on the LPC. And we're not finding them guilty. We're just expressing our displeasure at what they did. The LPC is free to tell us that these three judges are met. There's nothing wrong here. Or come and talk to us. Why did you engage in this thing? That would be my answer, Commissioner Baloyi.
Thank you, CJ.
Thank you, Commissioner Baloyi. One last question from me, JP Mlambo, and I raise this with you because it will most likely come up during deliberations when you are no longer there to express your views to us on the issue. You turn 66 shortly. How long would you serve in the position of Deputy Chief Justice if appointed? And should it matter that you are only slightly older than the other candidates, which puts them in a sort of an advantageous position because they would serve a little longer than you if appointed?
CJ, thanks for that question. I will reach the age of 70 in 2029. That's 4 years and probably 3 months from now, because I turned 66 in September this year. So in September 2019, I'll be 70. So it's a period of 4 years and 3 months. Oh, sorry, I don't know how long it will take the president to make a decision. Yeah. So
hopefully not long.
Yeah. So it's a period of 4 years, CJ, and there's nothing I can do about it. I was born earlier than my two brothers, and one of them actually is a year younger than me. Not a lot. The other one is quite a youngster. I say this respectively.
Just slightly older.
Yeah. So, but CJ, that's where I can put it. I mean, if it's a concern, it shouldn't be a concern. I think the CJ will be serving until 2034, if I'm not mistaken.
Something like that.
Somewhere there. So, from a career development point of view, and this is me sort of advancing my case, it would serve the CJ quite well to have a candidate who will leave before her and bring in someone else as DCJ who can take over from her when she goes. I think it's a way of looking at it.
That's a very smart answer, JP Mlambo. Thank you very much, JP. And thank you for accepting the President's nomination for this vacancy. And for your patience with us today. It's been a longish interview, longer than one anticipated it would take, but you handled it gracefully. So unless there's anything you wish to raise with us, you're free to go.
Chief Justice, I want to thank you, the commissioners, for inviting me to this interview. I take this process seriously. And as I've said in my presentation, it's a very important position in the judiciary landscape, the position of Deputy Chief Justice. And I hope I have helped you and the Commission in forming a view about me. And I leave it at that. But thank you very much for interviewing me.
Thank you, JP. You're free to go. as I said. Colleagues,